All right, Gina, you ready? You on the phone? Gina, are y'all ready? Yeah. Okay, let me know. I don't know that there's been a time I've come and they've not had some sort of problem. All right, I'm going to call to order the August 12th, 2026 magistrate docket to order. My name is Hayward Dykes. I am the special magistrate that will be hearing the cases this morning. If you have a cell phone, please turn it off or put it on vibrate. I'm going to go ahead and swear anyone who plans to speak this morning, present evidence or testimony, if you'll please stand and raise your right hand. All right. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, thank you. All right, our first case this morning is 26742 MG Caleb Malin and Officer Kieran Williams. We have Mr. Malin and Officer Williams here. Okay. Is anybody here on behalf of Mr. Malin? Okay. Is the county ready to proceed this morning?
Yes, sir.
All right. Whenever you're ready, Officer Williams.
Okay, on April 18th at approximately 3:13 p.m., while doing checks on Grayton Drive-On, I observed a black Toyota Tacoma backed in on the beach. While I was checking the front windshield to make sure if it had a permit to be on the beach, I did not see one. So a citation was issued to Mr. Malin because of that.
All right. Do you have any evidence you plan to
Yes,
present
sir.
this morning? All right. Approach. All right. So I've been handed a copy of the Section 22-57 permitted vehicles on the beach. I'm assuming you highlighted the red part, the permit decal shall not be altered or modified?
Yes, sir.
Okay. Some photographs showing there's signage along the beach access, advising of fines, and that you can't drive on the beach without a permit. So 3 of those photographs. Got a photograph of the citation made out to Mr. Malin. And then these appear to be screenshots of body cam footage?
Yes, sir.
All right. And that's, is that Mr. Malin in the photograph?
Yes, sir.
All right. And you engaged with Mr. Malin? Did he advise he was unaware of it? Looks like he might have a out-of-state license.
Yes, sir. He stated that he had just moved to the state of Florida and that he hadn't had a chance to change his tag or his license.
All right, I'll accept into evidence the packet of information provided by Officer Williams. Is there anything else, Officer Williams, this morning?
One other note, this is the second time I've been subpoenaed for this same case. I didn't know, and he's not shown up.
Okay, well, we're going to resolve it today.
Okay, thank you, sir.
Anything else?
No, sir.
All right. Thank you, ma'am.
Yes, sir.
I'll go ahead and close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find based on the testimony and evidence presented this morning by Officer Williams and the evidence presented, there is sufficient evidence to show that infraction had occurred, specifically an infraction of driving on the beach without a proper permit, violation of 22-57 of the Walton County Code. As such, the violator is found in violation. There will be a $500 fine imposed, a $50 administrative. Okay, Mr. Crook, you need to turn that down or we'll go outside. All right, clerk processing fee of $25 for a total due of $575. I'll order that Mr. Malin has 30 days to pay that. All right. Our next case is Darlene Burke and Officer Posey. Do we have Officer Posey here? And is Miss Burke here? Okay. Ms. Burke, if you want to just grab a seat at that table. The way these, for other individuals who are here this morning, we'll, if you're coming up, you can just have a seat where Ms. Burke is. We'll allow the officer to present any evidence or testimony, give you an opportunity to ask questions of the officer, and then I'll allow you an opportunity to present any evidence or testimony you wish for me to consider. All right, so Officer Posey, is the county ready to proceed this morning?
Yes, sir.
All right, and Ms. Burke, are you ready to proceed this morning? All right, thank you both. Officer Posey, when you're ready.
So while I'm routine patrol in Seagrove Beach on June 28th at about 4 o'clock, I patrolled through the San Juan Beach access and noticed a vehicle parked across the lines, taking up 2 spaces. So I wrote a citation for not parking completely within the marked space.
Okay.
I have a photo if you'd like to see it.
Yeah, any evidence you wish to present this morning? Have you shown a copy, or does Ms. Burke have a copy?
Yes, sir. I just gave her a copy.
Okay, yeah, you can approach.
And I also have a copy of the ordinance if you'd like to see that.
Yeah, whatever you want to present, I'll take, if you want to present it, I can just look at it, however you want to do it. All right. Thank you, sir. All right, I've been handed by Officer Posey, a copy of a ordinance, section 20-12, parking spaces marked, that's highlighted, as well as sub B that's also highlighted. And then I have a photograph of a LSV license plate 91V CPZ, 2 photographs of that vehicle. All right. I'll accept that into evidence. Is there anything else, Officer Posey, that you wish to present at this time?
No, sir.
Ms. Burke, do you have any questions for Officer Posey at this time?
Well, I guess my question is really around, I see the issue, my ticket got first tested.
Yeah, it looks like the ticket.
So that's where I'm confused as to why I'm being charged for a handicap violation.
So the clerk of court brought that to my attention. I've since corrected the original copy. I changed it to illegal parking. If it were a handicap violation, there'd be a $250 fine.
Well, yeah.
So it's a $125 fine that is notated on there, and it should also be notated on the back.
Yeah, no, I see that.
So, Officer Posey, at the time you issued the citation, you inadvertently marked the handicap parking instead of illegal parking. The citation I have, at least that was presented from the clerk's office, does show, it looks like the handicap parking was scratched out, illegal parking was marked, and then there's initials KP. I'm assuming those
Right, those are
your
my initials. I went to the clerk of court's office and made those changes. I just assumed that maybe you had called them and inquired about it. That's why they were
No, I
asking me
thought
to make
this
those
was the only
changes.
way I could address that, that's why.
But it was my mistake that I checked off handicap. It's just a parking violation.
All right. Any other questions, Ms. Burke, for Officer Posey? All right. All right. At this time, Ms. Burke, it seems like there might have been some confusion on what you were charged with. I will say that it appears Officer Posey has amended his citation, which is allowed. So at this time, we are only going forward, not for handicap parking, but illegal parking. what we're addressing this morning. So, Officer, if you have anything, I'll allow Officer Posey to sit down, and you can present anything that you wish for me to consider.
That's fine. I was just confused.
Okay. Okay. Understood. All right. So at this time, just so I'm clear, Ms. Burke, you don't have any evidence or testimony?
No.
Okay. All right.
I wasn't actually, admittedly, we just moved here. I was not aware because I pulled up that parking spot over and saw park that way. So
Understood. All right. All right. At this time, I'll go ahead and close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that there is sufficient evidence to show that a violation has occurred, specifically a violation of Section 20-12, parking spaces marked. Is that 125 or 100 and
175.
175 total?
Yes.
Okay. I'm going to reduce the fine amount to $75 instead of 100. There is going to be partly, Ms. Burke, just so you understand, there is a clerk admin fee of $50, clerk processing fee. So that's going to put us at $150. I know that's probably a little solace to you, but that's about all I can do at this point.
is there a way? I would have
Understood.
I thought my only recourse was
Yeah, and I don't control any of that.
I
So
know, I appreciate it.
you would have to either get with the clerk's office or county to see if there's a better process to be put in place for that. But will you be able to pay this within 30 days, or do you need a little more time? All right, I'll order that this be paid within 30 days. Again, Ms. Burke, that's 150 total, and I'm signing the order, and you'll get a copy of that. You can pay that at the clerk's office. I would probably give it till, what, this afternoon, maybe? Till this afternoon before you try to pay that, because they're not going to have that in the system.
It does seem a little steep that somebody made a mistake.
Okay. Understood. Thank you, ma'am. Your case is over. We're next going to call Jeffrey Coffelt, Coffelt, or I'm sorry, Jeremy Coffelt. Is okay, what's your name, ma'am? All right. All right, Ms. Coffelt, you can grab a seat then. And we have Officer Ford.
Yes, Your
All
Honor.
right, Officer Ford, are you ready to proceed?
Yes, sir. On,
Hold on 1 second. And Ms. Coffelt, how do you pronounce that again? Coffelt. Ms. Coffelt, you're ready to proceed this morning? All right, thank you. All right, Officer Ford, whenever you're ready.
on June the 8th, at approximately 2:30, while conducting a routine patrol of problem parking areas along 30A, I observed the subject vehicle parked on a sidewalk at the Lake Causeway Beach access in violation of Section 2050 of the County Code and Florida Statute 316-1945. I issued the citation in accordance with standard procedure and resumed patrol without incident.
All right. Do you have any evidence you wish to present this morning, Officer Ford?
Yes, Your Honor, I have photos of the violation.
All right, and did you provide a copy to Ms. Coffelt? All right, thank you. All right, Officer Ford's handed me two photographs. Appears to be a gray Suburban, license plate FC5JP. All right, anything else, Officer Ford?
No, sir.
All right. Ms. Coffelt, do you have any questions for Officer Ford? All right. Officer Ford, you can grab a seat. Ms. Coffelt, if you want to come up to the podium, I'll consider any testimony or evidence you have.
Yeah, I came today because this parking area is somewhere that I've parked many times and I've seen other people park many times. And I didn't even realize that was a sidewalk. I just thought it was part of like the parking area. And there is a lot of like sand and debris on that area. And so I was just kind of surprised, just because we've been parking there for many, many years. So wasn't really aware that it was a sidewalk because it just seems like part of the parking area.
Okay.
That's all I have.
And I do see, like, there does appear to be some gravel that covers a portion of that. Does the Officer Ford or Ms. Cofelt, does a sidewalk go all the way down the length of the parking area?
Yes, sir. It's a busy sidewalk. It leads to the neighborhoods north and east of Oyster Lake and directly across from the Lake Causeway itself. So it is highly used by the residents of the neighborhood. And blocking that forces people to walk on the gravel behind the cars that have to back out from the parking area. So it is a safety issue.
No, I understand that. And like I said, my question was more whether it kind of ended right over here or if it goes the entire length all the way down to
It
the...
ends it turns sideways and actually goes to the boardwalk over onto the beach.
Okay. I appreciate that clarification. All right. Ms. Cofelt, anything else based on my last question or Officer Ford's comments about that?
No, it does end right at the front of my vehicle where it was at. You can't see it from the pictures, but yeah.
All right. All right. I appreciate that. Anything else?
Nope.
All right. Thank you, ma'am. You can grab a seat. I'll accept into evidence the 2 photographs presented by Officer Ford. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that based on the testimony and evidence presented, there is sufficient evidence to show that infraction did occur, specifically an infraction of parking on the sidewalk, which is a violation of Section 20-50. Based on that, I'm going to order there be a $100 fine, a $50 clerk administrative fee, and a $25 clerk processing fee for a total of $175. Ms. Cofelt, can you pay that within 30 days? All right, I'm going to order that be paid within 30 days. As I told the last individual, you can pay that at the clerk's office. I would just recommend that you wait, if you plan to try to do it today, that you wait till later this afternoon, because it won't be in the system if you go right now. All right, best of luck to you, ma'am. That concludes your case. Our next case is listed as T.C. Conray, case number 26-1763. I have Officer Cowley. Is Officer Cowley here? All right, and are you Mr. Conray?
No, Your Honor, I'm Mr. Conroy. It's the wrong name.
Oh, Conroy, okay,
I believe also the address is incorrect as well.
okay.
I'm the person that you're looking for.
Okay, we'll go over that in a moment. You can grab a seat, Mr. Conroy. Officer Cowley, is the county ready to proceed?
Yes, Your Honor.
All right, and Mr. Conroy, are you ready to proceed?
Yes, sir.
Okay, great, thank you both. Officer Cowley, when you're ready.
I'm Officer Cowley here to present a case against Mr. Conroy regarding a dog off-leash ordinance violation 2231A2. At approximately 4:45 on June 26, 2026, I observed Mr. Conroy throwing a Frisbee with his dog in and out of the water in the area of Wall Street Neighborhood Beach Access in Walton County. The dog was off-leash. As I approached, he put the dog on the leash. I obtained his permit number at this time. Continued my patrol. On my return cycle back, around 5:15, I returned, and Mr. Conroy had the dog back off the leash in the water. I recognized him from previous encounters. I believe this is about my 4th one with him, trying to explain the leash is always required to be on the dog when you're on a Walton County beach. We had a little altercation regarding the mean high water line. I explained it still needed to be, the dog still is required to be on leash at this time.
Explain to me what's the significance of the mean high water line?
It is not significant to us as it's a surveying term, but that's the term that Mr. Conroy used.
Well, I guess, how's it significant related to the dog off leash? Are they allowed to be off the leash if they're
No, sir.
beyond the, okay.
I have a copy of the ordinance violations for you and the ordinance about direct control of the dog.
Okay. Have you provided a copy or at least shown that to Mr. Conroy?
I have one now.
Okay. All right. Thank you, ma'am. All right, I've been handed a copy of section 22-31, animals on the beach.
I also have the last 2 years of animal permits where they have signed and highlighted where you are required to have the dog on a leash.
Okay. Are you going to present that?
Yes, sir.
Into, all right. So this is the Walton County Annual Dog Beach License Application. Appears to be filled out by Mary Conroy. One is August of 2025, and the other is July of 2026. All right. And you wish to introduce both of these into evidence?
Yes, Your Honor.
Okay. I'll accept those into evidence.
I also have a thumb drive of my body cam.
All
I
right.
was not able to gain photos.
Understood. We'll hold off on that at this point. I'll allow Mr. Conroy to ask any questions if needed. Are we going to be able to look at that if we have to? We've got a way to show those. I'm sorry. Okay. Well, let's see how far we get with. Okay. Well, let's see if we need those. All right. Anything else from you at this time, Officer Cowley?
No, Your Honor.
Okay. Mr. Conroy, do you have any questions of Officer Cowley at this time?
Yes.
Okay, go ahead. I'm sorry, if you would, just shift over, and if you'll come up, we do record these. It'll give maybe the best record we can get. So, Mr. Conroy, you can go ahead and proceed with your questions to
Thank you,
Officer
Your Honor.
Cowley.
Officer Kelly, at any time, did you see or observe the dog in question, who's known to you, above the high water mark, not on a leash?
Doesn't apply in this case, sir.
That's not the question.
The high water is a surveying term. It is not visible to the eye.
At any time, I'll rephrase my question. Did you see or observe the dog ringer who is known to you as a friendly and cooperative dog beyond the area of the water's edge?
Yes, he was in the wet sand.
Okay, so the water's edge, and Your Honor, I would like to bring into awareness section 22, TAC 02, under definitions of the Walton County Code. Water's edge means the portion of the shore at any given time of the day where the tide flows and reflows along a body of water. Now, this is a very important distinction in what I'm trying to say here. It is not, does not, as I use the term mean high water as a federal and law enforcement term.
Okay, hold on. So I'm going to allow you to present testimony in a minute. Do you have any other questions of Officer Cowley at this time?
I would like to clarify to Officer Kelly what the water's edge is defined as in the Walton County Code, and then rephrase my question. Have you ever observed a dog not in the area of the water's edge as defined in the code?
He was in the wet sand.
I believe that doesn't answer the question, Your Honor.
Okay, well, that's her answer. I mean, so
Right.
you may not like the
Okay.
answer, but
All
that's
right.
her answer.
Thank you, Your
So
Honor.
you can ask her another question or a follow-up, or you can show her some evidence if you like and ask her a question, but just because you dislike the answer doesn't mean that's not her answer. So I'll allow you to ask any other questions you may have.
Have you ever observed me on the beach without a leash
Yes.
for my dog?
Yes.
I do not believe that's true.
Okay, well, you can testify to that.
Okay.
But that's her answer.
All right, thank you. And I was concerned that you said there was an altercation. Because I consider our relationship fairly amicable. And I would like you to just explain what altercation meant or means.
The discussion of the high water line.
Okay, that was a discussion.
Refusal to put the dog on a leash.
No, I did not, I never, okay, thank you. I have no more questions, Your Honor.
Okay, great.
This, okay,
no.
correction, he was not a refusal. His belief was he is south of the high water line, therefore the dog did not need to be on a leash.
Thank you, Officer Callie. You can grab a seat. I'm going to allow, I'm sorry, do you have any, since you made that statement, I'll open it back up. Do you have another question for Officer Callie just based on that last comment? If you don't, I'm going to let her sit down and then I'll let you
Thank you,
present.
no further questions.
Okay, Officer Callie, grab a seat, please. Mr. Conroy, now's your opportunity to dispute what Officer Callie says, present any other evidence or testimony.
Thank you, Your Honor. I come here grateful for my opportunity to speak before the court. I believe my actions were lawful, responsible, and respectful of all citizens and guests. I would like to make clear that this is a non-nuisance, friendly, well-behaved dog who was leashed when on the beach. And beach, I would like to bring into Section 2202, definitions of beach. Can I don't know that I have I might have a copy of it, I don't know. Do I need to present a copy of the old code regulations?
I'm sorry, are these old code regulations or current code?
Current.
Okay. And you said that's section what?
22-02 dash definitions.
Okay. And this is
And
the same section as what Officer Callie presented?
It's the section that immediately precedes it,
Okay.
and it defines the terms that are used as I understand it. Not being a lawyer,
No, that's
I'm
fine.
trying to connect the
I'm
dots.
trying to pull it up as but if you want to go ahead and read
Right,
it.
so beach, as defined in section 22-02 dash definitions, beach means the soft, sandy portion of the land lying seaward of the seawall or of permanent dune vegetation. Now, in a vernacular, to simplify my understanding of that, that means the sandy beach where people generally will sit and lay out on the beach, set up umbrellas, play ball, whatever. The idea of the statute being the county does not want dogs running around on the soft sandy beach as defined. Now, there's also another term called the water's edge, which is separate and distinct. And I believe it's significant in the distinction that water's edge means the portion of the shore at any given time of the day where the tide flows and reflows along the body of water. In other words, what I summarized on the ticket was below the high tide line. Commonly, that's what's referred to, and that is not in dispute for this ticket. One of my cases, my dog was not on the beach as defined by the Walton Code and was classically on the water's edge. I also wanted to say that I go to great lengths to be considerate of anyone who happens to be walking along the water's edge. If people are walking down, I go to the beach and with the dog and only throw the Frisbee into the water. And if other people are walking down the beach, I put the dog on a leash and ask the people walking by, hey, this is a good dog, friendly dog. In this particular case, there was a family of 4, and they were from Atlanta. I don't know who they are, but the kids under 10, between 6 and 10, and the father and the wife. And when they walked down, I put the dog on a leash, asked them, hey, this is a friendly dog. And they said, hey, it's no problem. We like dogs. And so when they were coming back on the beach the other way, I was going to put the dog on a leash. They asked me, you don't have to. And their kids were actually throwing the Frisbee for my dog. So I'm trying to be a responsible citizen. And I think the water's edge, because it has to be a different term than the beach, applies here. And therefore, my dog was not on the beach, and this ticket is unwarranted. That's my position, Your Honor.
Understood. So, and let me ask the question, because I was able to pull up as you were going over your, so the section, I did find the definitions, and so the beach, as defined in the Walton County Code, says beach means the soft sandy portion of the land lying seaward of the seawall or the line of permanent dune vegetation. So it would seem that if the vegetation, because we all know vegetation doesn't go to the edge of the water. So if it's at the dune vegetation, that would seem to encompass both dry as well as to the water's edge.
Your Honor, I see the dune vegetation as being the sea oats that are classically on the dunes that are beyond the sandy beach.
Right, and this says the beach means the soft sandy portion of the land lying seaward.
Right, in other words,
So
towards the water. Right,
Towards the water. And if there was a seawall there, we would take it from the seawall.
correct.
And that would mean if the water's hitting the seawall, then that would be the water's edge, right? But if there's land between the seawall and the water's edge.
That would be the
this
soft
would-
sandy beach.
Right, and this
Yes,
would
sir.
encompass all of that as well as the line of permanent dune vegetation. So you're saying as long as the dog is off leash and beyond the water's edge, then that's a deficiency in the code and you're allowed to have the animal on that part of the beach.
Correct. And the animal is acting in compliance with all applicable laws, regulations. In other words, it's not a nuisance animal. It's well-behaved, and it's undergoing training for sport hunting.
Okay, well, and I don't think that clarification is made in 22-31. It just, the plain language states, who have obtained a permit, which obviously you have,
Yes?
and who maintain direct control of the dog on a leash. Because I do understand there are certain codes or certain rules that sometimes allow, if you have voice control of an animal, that's allowed and they don't have to be on a leash. But this section with animals on beaches, it says who maintain direct control of the dog on a leash. But I understand your argument in that you see the beach is only
The soft sandy portion,
sandy portion,
not the tidal.
not the water. All right. Anything else?
Yes, Your Honor.
Okay, go.
I'd like to, and I'm not sure how this all flows through exactly, but I would like to cite Article 10, Section 11 of the Constitution of Florida. The title to lands under navigable waters within the borders of the state, which have not been alienated, include beaches below mean high tide water lines, is held by the state by virtue of its sovereignty in trust for all the people.
Okay. I'm familiar with that part. Would you like? Sure, if you want to give it to me. All right. Have you shown a copy of this to Officer Cowley?
I have not, but I will.
All right. And Mr. Conroy's provided a copy, looks like a website printout for sovereignty lands, Article 10, Section 11. And that's lands related to navigable waters. All right.
And that's, it also it brings into the term the mean high water mark. I wanted to, so, know that was called into question, well, what that was, and so that's,
Right. It mentions including beaches below mean high water lines. Okay. All right. Officer Calley, I'm sorry, Mr. Conroy, anything else?
I don't think so at this time, Your Honor.
Okay. Officer Cowley, do you have any questions for Mr. Conroy? Okay. What is your, or I guess what's the county's rebuttal to Mr. Conroy's argument that there may be a gap in the code that says beaches are the sandy portion of land lying seaward of the seawall or the line of permanent dune vegetation, and then there's also language in that same section, water's edge means that portion of the shore at any given time of the day where the tide flows and reflows along the water. So as far as there being a distinction between those two areas.
Your Honor, I believe it's also critical that it's the soft sandy part.
Understood. Go ahead.
As far as code is concerned, the wet sand is an area for traversing. It is considered a Walton County beach. The permit that they do sign, that they apply for, states the dog must be in direct control while on a Walton County beach. The wet sand is considered a Walton County beach.
Yeah, and I think the code as well as the application is clear that you must have direct control of the dog on a leash. I don't see any wiggle room for that, but I am curious as to whether or not there's a distinction, and you're saying the county doesn't recognize any distinction as far as the mean high water line or what is considered the beach.
No, Your Honor. It just simply states any beach owned or maintained by Walton County. And the wet sand is considered the traverse zone.
And Your Honor, I would also put forth, if it was the same, then why would there be a distinction? Why is it necessary to have that definition? As it ties back into, I don't know if derivative is the right term, derivative of the Constitution of Florida.
Okay. Anything else from the county on this?
Sure. We do have a pattern in the last couple of years of a prior verbal warning about the dog an hour outside of the dog permitted times.
I'm sorry, say that again?
This is not an isolated incident. I have a couple cases in the past where the dog was off leash and also a time violation.
Okay. Well, I mean, I'm not.
Oh, not for my dog.
Yes, sir.
No.
Okay,
that's
okay, hold on, guys. We're not here for that. We're only
Right.
here for the citation that
Thank you.
I have in front of me this morning. So I'm not going to go into or consider, I guess, prior incidents that Mr. Conroy may or may not have had on the beach with his dog.
Different dog, different.
As it relates to this, is there anything else as it for the county on this citation?
No, Your Honor.
Anything else from you, Mr. Conroy?
No, Your Honor, I'm grateful for your consideration, and it was a different dog with a different situation, and it was on the sandy beach, and it was out of time, and I did pay the fine. Different dog, different scenario, 100%.
Understood. All right, thank you both. You can grab a seat. All right. Uh, Let me ask both the county and Mr. Conroy. So I'm looking at the definitions of beach or beaches, and it says what we've discussed in 22-02. The language in 22-31 mentions that all animals, this is sub A, all animals shall be prohibited from public beaches of the county except, and so I think my struggle is I can see where Mr. Conroy's argument is persuasive to a point, but I guess my question to both parties would be, would public beaches cover both, obviously, the sandy part, but also the wet part, right? So if the water recedes based on tidal flow, that are we suggesting that that land's only policed by the state, or would that also be policed and governed by the county because the county has authority to police that part of the beach? So looks like Mr. Conroy wants to speak first. I'll hear from you.
Well, Your Honor, I certainly would defer, but I do have an opinion on that. If you,
Yeah, go ahead.
a couple of points. It would not be out of the jurisdiction of the county, even if it's below the high mean tide water line, or we'll say the water's edge. But that is separate and distinct, and the rule is for beaches. It is not the beaches. It doesn't preclude code enforcement at all. But it is not the beach as defined in your regulation and code. I would also point out to section 5-29, exceptions for training for sport hunting, that authorizes dogs to be used off-leash for training.
Sorry, 5-29.
5-29. There's a training for sport hunting. That's under the exceptions.
Yeah, but that appears to be for when not on the owner's premises or the premises of another who consents thereto. So it would appear that you would have to have the consent of that owner.
Well,
And in this case, you have the county's consent, but they say you must have direct control of the animal.
The way I read section 529, Your Honor, was that was an exception for public lands under the exceptions and not under the private use on the private land. But that brings into question, if it was a private beach, could I then use the water?
Yeah, I think this is
So
only,
that is not in the jurisdiction then.
right. So if you were on private property, I think you would have a different set of rules because it's private property. Because you have to go to the county to get a permit to be on the county's beaches. You don't have to get a permit if I had a beach house.
I do believe there's legal precedence where it says that the private property ends at the water's edge. Your Honor.
Right, but you weren't, I mean, nobody's dispute, are you suggesting you were on private
What
property?
I'm suggesting is that there's a reason why there is a water's edge, and it is separate and distinct, and that distinction is significant as it relates to how enforcement of the code.
No, I don't disagree that that is a point that is argued vigorously by attorneys when it comes to property rights.
I don't know any attorneys who've argued that, but so that's out of my purview.
Right, but I don't know that Section 529 helps you the way you think it does, but I do want to focus just on your other arguments as it relates to the beach portion.
So, Your Honor, would that mean that if the dog is swimming in the Gulf of Mexico, it needs to be on a leash?
I guess it would matter how that dog got out there. If you got him out there on a boat, then it probably becomes less of an issue, right? If
How
you
about
come-
if you had a, I'm sorry, Your Honor, I didn't mean to.
Yeah, and I don't want to get here and go over
Right,
what
right.
ifs all day.
Right,
I mean, we have
a
other
certified,
cases.
licensed, current, well-behaved, non-nuisance, on a leash, walked across the beach into the water.
I'm not arguing that your dog is unbehaved. I'm not arguing that your dog is a bad dog. Nobody here is saying that, okay? The key points that I'm looking at is, did you have direct control of your dog via a leash, which is required under county ordinances as well as the application that you sign, okay? So I think you cannot check that box. But I do find, as I said earlier, your argument somewhat persuasive. That's why I had the follow-up question, and that's why I've taken the extra time to hear your argument related to what's considered the beach versus is there an exception or is there a loophole in the code that says, hey, as long as we're on the wet sand, then somehow we don't have to follow any, because not only this portion of the code, it would pertain to any part of the code related to county beaches. So I need to, I'm asking for that distinction. I think you've made that, but if you have another point, I'll hear it, and I'll give you some time, and then I'm going to hear from the county, and then we're going to close this hearing.
Thank you,
all right?
Your Honor.
So if you have something else, again, I'm not going to go over what ifs and all that. We're going to talk about the situation and the citation that we had. Is there anything else that you want me to consider?
I just, no, Your Honor, I'm grateful for your consideration.
Okay, thank you, sir. All right. Officer Calley, what's the county's position, or what's your argument related to whenever we hit the water's edge, that, where I guess more, my question earlier was more of when the water recedes, then that land between the water's edge and that has now become wet is somehow out of the jurisdiction of the county.
It is my understanding that Walton County owns 9 miles into the Gulf. The wet sand is designed for traversing. If somebody were to come in on a neighborhood beach access to walk down to the water's edge to traverse to a public property. It is for everybody to be able to traverse. It is still considered a Walton County beach.
Your Honor, the distinction is, again, as was made, there's a reason why it's called the water's edge and not beach. It's not defined as the beach.
No, I don't disagree. There's a difference between being in the water and being on the beach. And that's what I'm struggling with is this an exception? Because the section of the code that you were cited with says shall be prohibited from public beaches of the county. And I'm trying to say, well, what's considered the beach? And I'm familiar with a lot of the litigation that went on related to what's private property, what's public property, and I know that there is as Officer Kelly pointed out, this distinction that allows the public to traverse the wet sand area. And that doesn't mean they have to be ankle or knee deep in the water, but they are allowed to traverse that part of the beach, and the county does police that part of the beach. So, but I do see your part, your argument that, hey, it mentions this sandy beach. Now, it doesn't say wet sandy beach or dry sandy beach. It just says sandy beach. And I don't know that if it said dry sandy beach, I do feel like this would probably be a shorter hearing.
Soft sandy beach?
Yeah. It does say soft sandy beach. So, all right. Anything else from Mr. Conroy or the county?
No, Your Honor.
All right.
And,
Mr. Conroy?
Grateful for your consideration, and just wanted to also let know that it is part of the Florida Constitution about the mean high tide mark. And thank you, Your Honor.
All right. You can grab a seat, Mr. Conroy. All right. This time, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that based on the testimony and evidence presented that there was sufficient evidence to find a violation had occurred on the or in this case specifically, let me pull it up, a violation of 22-31A2, observed dog off the leash. I will say that Mr. Conroy made a very compelling argument that the ordinance language does say soft sandy beach. It does not differentiate between dry or wet, and the county's position that it does have authority to police even the wet parts of the beach, I believe, is what became most persuasive to me. So I'm going to find that there is a violation. Having said that, I'm going to order a fine of $10. There's going to be a clerk administrative fee of $50 and a clerk processing fee of $25. So that's going to be a total of $85. Mr. Conroy, can you pay that within 30 days? Okay, we don't have the capability to take it right now, but if you wait till this afternoon or the next day. And Mr. Conroy, you brought up some good arguments, so if you want to engage an attorney and see if you want to go argue this up to the court, you're welcome to do that. I'm not suggesting that I get everything correct, but I think you made some, as I said, compelling arguments this morning. So,
May I ask a question?
yeah, but do be advised, I'm not going to give you any legal advice.
If I was seaward of private beach, would this be a violation?
I'm not going to answer that. You're asking me for a legal opinion. I'm not your attorney. I would, if you want to get that advice from another attorney.
I was just looking for sound judgment, so we don't
Yeah,
have to come back.
we'll deal with that if that comes up. But yeah, I'm not going to sit here and speculate on that. All right. All right. Best of luck to you, sir. Thank you. All right. The next case is Kenneth Crook, case number 26-985. All right, and Mr. Crook is present. And we have Officer Ford. Is the county ready to proceed, Officer Ford? All right. And Mr. Crook, are you ready to proceed? Yes. All right. Whenever you're ready, Officer Ford.
On May the 16th of this year, while conducting a routine patrol of problem parking areas in the Blue Mountain Beach area, approximately 3:30, I observed a vehicle registered to Mr. Crook parked in a clearly signed and marked handicap access space, not displaying a permit visible from the front of the vehicle, violation of Section 2012 of the county ordinance and numerous Florida statutes. I attempted to ask people nearby if they had seen anyone. Several people said they had not. I waited a few minutes. I carefully checked the vehicle, both from the driver's side and the front, to see if I saw any sign of the permit, possibly on the dash or under the visors, and not seeing any trace of a permit. I issued a citation in accordance with our standard procedures, and then I resumed patrol without incident.
All right. Do you have any evidence you wish to present?
I have photographs, Your Honor.
And you provided a copy to Mr. Crook?
Did.
All right. Approach. All right. Thank you, sir. I've been presented, excuse me, by Officer Ford, 3 photographs, one photo is of a Kia Sportage with a license plate IN as in Nancy, G as in George, 71. a photograph that appears to be from the driver's side of that same vehicle from the window, and then a front shot of the vehicle with the handicap sign in the background. Okay. And Officer Ford, it looks like, did you initially cite the owner of the vehicle for illegal parking and then change that?
It was an accidental strike-through, which I initialed at the time I did it to show that I had corrected that.
And it looks like in the details you marked that it was parked in a handicap space, no permit displayed. Okay. All right, I'll accept these photographs into evidence on behalf of the county. Mr. Crook, do you have any question, or I'm sorry, Officer Ford, is there anything else?
No, sir.
Okay, Mr. Crook, do you have any questions for Officer Ford at this time?
I believe it was your testimony.
All right, hold on, Mr. Crook, if you come up. Thank you, sir.
I believe it was your testimony that you went to the driver's side only of the car. It appears you've got a picture of the front, the driver's side, and then the rear of the car.
That's
Is that
correct.
So you didn't go to the passenger side at all?
I did not.
Okay. So you really didn't do a thorough search of the car to see if there was any evidence of a deal there? You only looked on the driver's side and on the front of the car and the rear of the car?
I only looked where it is supposed to be presented by state law.
So why did you take a picture of the driver's side then if you were only supposed to look where it was supposed to be
I
presented?
was trying to give you the benefit of the doubt.
Okay.
And if it is placed in a accessible area and I can see the control number and the expiration date, I would count that as being
Okay.
properly displayed.
So if, for instance, it had dropped down here and was laying right here on the console as your pictures show, and you could have seen those things, then you would not have issued a ticket.
I would not have issued the ticket.
That's all.
All right, thank you, sir. Mr. Crook, whenever you have any testimony, evidence you wish for me to consider.
So, Your Honor, what I've presented to you is the order appointing me as a guardian of my brother as an incapacitated person. That's the reason why we have a handicap placard that was in the car and properly displayed when I got out of the car on that day. My wife would love to give testimony, and I had to disconnect with her because my phone is down to almost zero battery, waiting on being able to get here. But she works at Mayo Clinic, and I'll be glad to reconnect with her in just a minute if we need to get her there. But that, shows that there's a reason for us having a handicap. My brother is here with me in the court here. He has got dementia, and his walk is far worse than Joe Biden's ever was. He does not have the capability to get down to a beach if it's longer than where we're at, things like that. When we went on a vacation recently, we had to put him in a wheelchair to get around because it takes him probably 3 or 4 times as long as we to get to certain places along the way. The picture I've got there is, of course, with my wife and my brother in the car with the placard that I have right here displayed in the car. And that's what I did when I left the car. That's my testimony that I put up there. And that would be my wife's testimony, that when she left the car, she has seen me put the placard up on the windshield as it is there. There's a closer up picture of that, and then there's a closer even picture there where you can see my wife's shoulder and my brother's shoulder in the car that's there. So we were at the beach with him, following state law, things like that. So a little bit of background. I'm a former county chancery clerk, so I'm familiar with court proceedings and what we need to do and such. And in the hearing of legal matters that are ordinance-based, there's a consideration of both the law and the facts. And I attempted to follow the law on this thing, and the facts is that there was a placard in display in the car when I left the car. But, in certain circumstances, things happen. My wife will testify that when she got in the car first, after leaving the beach, that she found the placard on the passenger side on the floorboard there. So it must have, when I closed the door, fallen off and fallen to the floor there. I can't testify that. I'm just giving you a hearsay that it was there because I didn't get back in the car first. When I got back in the car, there was a ticket on the windshield and the placard was back in the window, as displayed by the picture. So, you know, before being a clerk, I lobbied in the legislature in Mississippi, and I was there in the 90s when we rewrote these laws. And when we were writing these laws concerning handicapped parking spaces, the intent and purpose of the law was to give people who are handicapped access to places where they did not, you know, have access otherwise unless they did. So we were using a place for the benefit of my brother in compliance with what the law was. I would think that if I were in the legislature right now and I was asking them the question about if I made the intent to use that as the law was written, would I be in compliance? And I think they would say I was, even though it wasn't displayed for him. Had he gone to the passenger side, he would clearly have seen, according to my wife's testimony, would clearly have seen the placard on the floor there, and his picture would have evidenced that. But he didn't. He just chose the driver's side and the front windshield. And his own evidence here is that he'd seen it on the passenger side, even though it wasn't in the windshield, he wouldn't have issued a ticket. So I'm asking and making a motion for this to be dismissed and let us go on our merry way. We've got, I've got another meeting I'm supposed to be in here shortly, and I just, again, beg the court if I can move on with things and get this over with and dismissed.
Okay. Your motion to dismiss is denied, sir. And I think the testimony from Officer Ford was that had he seen the placard and been able to read and confirm that it was current and that it was for this vehicle, then he wouldn't have issued the citation. But I can have Officer Ford. This one shows, so this would have been this is a copy of the placard, or is this a renewed placard? Because this one shows a 07/28 expiration date. I know on the tag it shows a different expiration date. Okay, so this is a copy of that. Okay. And
You don't know about what.
okay, so it wasn't in that condition whenever you were at the beach?
It had the right.
Okay. And these photographs, were these taken the same day or were these taken at a different day?
You'd like to see my phone?
No, I don't need that. I just wanted to confirm if those were taken later that day. All right, Officer Ford, do you have any questions of Mr. Crook at this time?
No, Your Honor.
All right, anything else from the county?
The county would just note that the Florida statutes are extremely clear on this matter, and the failure to properly display the placard, regardless of the circumstances, is a violation of both the county and state statutes regarding handicap accessible space parking.
Yes, sir, understood. Mr. Crook, do you want to, I don't know that it's necessary, but I don't want to, dictate how you present your evidence or your case. Did you want to get your wife on the phone to testify, or do you feel comfortable with what's been presented?
If you accept my statements that was on the floorboard as evidence, then that would be sufficient. But if not, then she would have to be the one to testify because I can't testify as to where it was when I got back to the car.
No, I mean, I don't necessarily need that. If the county would like that, then.
No, Your Honor, the county does not dispute whether or not the
Permit. Okay. So, yeah, this is not necessarily that you don't have a placard. It's just a matter of the placard was not properly displayed. Okay. anything else? I'm not hearing that the county needs your wife to testify. I don't necessarily need your wife to testify. We'll take your testimony as,
Take a lot
on
of
its
pleasure in
face and just give it the weight we believe it needs to be given. Is there anything else that you wish to present? Argument, evidence, anything like that?
I just, again, believe wholeheartedly that in our form of jurisprudence that the law and the facts are established in every case and that they're all at your, at your judgment. If I were going down the road and I saw a house on fire and ran up to it and it had no trespassing signs on it, but I went in to get the people and rescue them out of the house, they could file no trespassing against me, and I would think that this court would dismiss those charges because I was trying to help those people out there. We, in full intent of complying with the law, put a placard on the windshield, on the rearview mirror hanger where it's supposed to go, and left the car to go to the beach. We had no idea until we returned back to the car that it was not there any longer. My wife is the only one who can testify that it was a floor. When I got back to the car and went to put my stuff in, I was really angry because it was sitting there on the windshield. And she says, well, I put it back on the windshield because it was on the floorboard. And I said, well, why is it on the floorboard? She said, I don't know. It must have fallen off when you left the car. But she was there with me and witnessed me doing it and putting it on the windshield. So we did everything to comply. It just happenstance, chose to go a different direction. That's why I asked for a dismissal.
Understood. All right. Thank you, sir. Anything else from the county?
I would just say, Your Honor, that we do frequently get calls from the public who are concerned when they see vehicles parked in a handicapped space without displaying a permit. So to allow, whatever the reason, the vehicle to be parked there does somewhat undermine the confidence of the citizens of the county that we are in fact enforcing the handicap parking regulations.
Okay.
Rebuttal, if I may, Your Honor.
All right, this will be the last. Go ahead.
I've parked in that parking space in the last 9 years over 1,000 times. The neighbors know me. They know it's a handicapped car. We have a Texas A&M decal on the back of it. It's been the same car for 9 years. So, I would suppose if he's been by there, he's seen the same car with the placard on the windshield as well.
All right, thank you, sir. All right, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find based on the testimony and evidence, there is sufficient evidence to show a violation has occurred for improper display of a handicap placard. Nobody disputes that Mr. Crook and his family appear to have a valid placard. With that being said, I'm going to find a violation. I am going to reduce the fine to $100. There is a clerk administrative fee of $50 for a total of $150. Mr. Crook, can you pay that within 30 days?
Is there a process for appeal?
Yes, sir. You can appeal it to the Circuit Court of Walton County.
I'll take 30 days.
Okay. I'll sign that order, and then you will get a copy of that. I'll go ahead and put in all the evidence that was presented, so that'll be with the clerk's office. You'll need to, if you hire an attorney, they can help you with that. If not, and you decide to do it yourself, just make sure you get a copy of all that to present to the court. Yes, sir. Yes, sir. Thank you. Our next case is Great Valet. That's Grayt, Valet, VALET, case number 26939. We have, I guess the interested party is Jonathan Pitts. Is Mr. Pitts here? And then we have Officer Busby. Officer Busby, is the county ready to proceed? Yes, sir. Right, whenever you're ready.
It's a little bit lengthy of a statement. We'll process it for a couple days. On 5/15/26 at approximately 7:30 a.m., I observed Jonathan Pitts whom I recognized from previous interactions, setting up beach equipment on Grayton Regional Access. Once he set up his equipment, he stayed there for about an hour and then left, leaving the chairs and umbrellas on the beach. I left the beach and then returned around 11, and I observed a group of females occupying the equipment that he had left there. Shortly after, Mr. Pitts returned, and he set up more equipment just right next door to where the ladies were sitting. I observed him shaking hands with one of the females, and it appeared that they had just met. And then he went and sat with the second set of equipment that he had just set up. I again left Grayton shortly after that. And then I returned about an hour later. Mr. Pitts had again left. Based on past conversations and interactions with Mr. Pitts and his company, Great Valet, I suspected that he was vending beach equipment as he advertises on social media while using his disability drive-on permit to deliver to the beach. I activated my body camera and approached the females that were using the equipment that he had set up that morning. I asked them if they would tell me what Mr. Pitts was charging them for his service, and they told me it was $175 per day. They had also confirmed that he had been there earlier. I did not make any further contact with Mr. Pitts that day. The next day, 5/16/26, I returned to Grayton around 6 a.m. and waited for a few hours to see if Mr. Pitts would return, as the ladies stated that they had rented his equipment for 2 days. I did not see him, so I called him, and he did not answer, so I left a message for him to call me back. He later sent me a text message stating that he, quote, barely does any business, and that he had spent 8 hours out there with his friends. He also stated that there are 3 active county commissioners that told him he did not need a permit to vend on the beach and that they would tear up any tickets we write to him. He also stated that we had called him about vending for the past 3 years, which is accurate, as he's been given warnings in the past. Based on further evidence that I collected throughout the day, which included text threads, photographs, body cam footage, and screenshots from his social media pages advertising for his business, I issued him a citation for violation of County Ordinance 2260B1 for vending without a permit on county beaches. Included in that packet I gave you, sir, was the definition, copies of my citations, and then various screenshots from text messages that he had sent me, pictures of his advertising on social media from Facebook and others, showing where he is getting paid, people asking if they received his payment, him, saying we're open for business, that kind of thing.
All right. I'll accept into evidence the packet of information. So it's made out to Great Valet, or Valet, rather.
Yes, sir.
Is the, now you can't get a beach permit.
So what we
or-
offer.
or driving on the beach permit in the name of a company, can you?
You can, but it's the only way you can get it's a temporary drive on if you're holding like a special event. Give you an example, Grayton Beach Catering, if they have big events out there, they do have a drive on permit, but they will request a.
But that's a separate permit from the,
His
I
is
guess you
just a
said it was
regular-
disabled.
Yeah, his is just a
veteran.
regular disability driving permit, but he uses that to haul his equipment out onto the beach and set up for vending.
Okay.
Only on Grayton. Now, I've got other cases against him where he's been caught on other beaches, but for this particular one, yes. And I do have the body cam footage, if you need it, me speaking to the females.
That's fine. I can take your testimony at this point. And these text messages that are included from May of 2026.
Yeah, the first one is where he had texted me after I had tried to call him. He never returned my call. He just sent me text messages claiming that he was in Orlando or something, which is why he didn't show up the next day. But I had highlighted where he was talking about the commissioners. The second text was actually provided by a citizen who reached out to him, and he gave them a quote for the same price, $175 a day.
So the first printout for text messages is between you and,
Mr. Pitts
okay, Mr. Pitts.
Yes,
And then
sir.
the second set,
was from a citizen.
okay.
Yeah,
And then I see the, what appears to be social media posts. Do you know whether or not these are, I mean, it has the same name, so I assume it's the same, but do you know, how do you know these are his?
there's a couple back where it's actually got his name attached to it. I believe it might be the black and white ones.
Oh, okay. Yeah, I see a,
John Pitts at the
looks
bottom.
like the, yeah, it looks like there might be a Facebook printout showing John Pitts is in Grayton Beach.
Yeah.
There's a reference to Great Valet.
Yes, sir.
Okay. All right. Anything else from the county on this?
No, sir.
All right. I'll accept into evidence the packet provided by the county. And I'll ask one last time, anybody here on behalf of Great Valet? All right. Thank you, sir. I'll close the evidence portion of this hearing. I'll find, based on the testimony and evidence presented, there is sufficient evidence to show a violation has occurred. Specifically, a violation of 22-60 sub B sub 1, based on that violation. I'll order that a $500 fine be imposed, a $50 administrative fee, and a $25 clerk processing fee for a total of $575. And that will need to be paid within 30 days. Our next case is Jacoby Properties LLC, case number 26-1312. Do we have Officer Knudsen. Do we have anybody here for Jacoby Properties LLC? All right, Officer Knudsen. I'm not sure if that's me or not. Oh, I'm sorry, are you, yeah, just under that it says Perry Brown. Are you Mr. Brown? All right. Yes, sir. Thank you for bringing that to my attention. If you want to just grab a seat. All right, Officer Knudsen, is the county ready to proceed?
Yes, sir.
All right, and Mr. Brown, are you ready to proceed? Yes. All right, great. Officer Knudsen, whenever you're ready.
All right, Your Honor, my name is Nicole Knudsen, and I am a parking enforcement officer for Walton County Code Compliance. On the day of June 5th, 2026, I observed a red 2021 low-speed vehicle bearing Florida license plate number QLLZ31 parked in a handicapped parking space at the Inlet Regional Beach Access. There was no handicap placard on the low-speed vehicle or handicap license plate displayed. I proceeded to take photos of the violation and wrote a citation using Ordinance 2021B. The low-speed vehicle left before I could hang the ticket, therefore the citation was sent certified mail. I have provided copies of the violation as well as copies of the verbiage of the ordinance I used to issue the citation.
Do you have any evidence you wish to
Yes, sir.
present? All right. Have you, you can go ahead and present that, and if you would, go ahead and give him Mr.
Yeah, there's
Brown.
also photographs of the violation.
Okay, just whatever you want to present. Thank you, ma'am. All right, Officer Knudsen provided me a copy of a printout of section 20-21, regulation of parking for persons with disabilities, and highlighted sub B permit requirement. And then a picture of certified mailing to Jacoby Properties LLC, which appears to match it has the address for Knoxville, Tennessee. It's also on the citation, a copy of the citation, as well as it's like 4 photographs of the low-speed vehicle in front of a handicap parking sign. And then the last, and there's a front picture of that same vehicle. And then the last is a printout showing ownership of that low-speed vehicle. Let me see something. Which does match the Florida license plate on the, one of the photographs, QLLZ31, showing that the title holder is Jacoby Properties LLC. Mr. Brown, did you get a copy of all that? Yes, sir. All right. I'm going to accept that into evidence. Is there anything else that the county wishes to present at this time?
No, Your Honor.
All right. Do you have any, Mr. Brown, do you have any questions for Officer Knudsen? No. Okay. All right. Officer Knudsen, you can grab a seat. And Mr. Brown, if you want to come on up to the podium, this will be your opportunity to present any evidence or testimony you wish for me to consider.
Yes, sir. Well, Your Honor, I appreciate the opportunity to come to speak. Me and my wife had took her mom and two of her friends to the beach. They've been maybe a couple times in their life. Her mom's 80 years old, Virginia Witt. Sarah Cox, which is a friend, she's 82. And Silva Armstrong, she's a friend, she's 87. And we just wanted to bring them down, let them enjoy the beach, let them sit by the pool, that kind of stuff too. The Jacoby property has that golf cart there, so it would not have any kind of placard on the tag. Virginia, Sarah, and Silver are all registered handicap. I've got pictures of the placards.
Have you shown those to the county yet?
I haven't, I've only got one copy.
Okay, show it to them and then I'll look at them.
By the way, I appreciate what all you guys do. But this is my plea, and I'm gonna try to keep it short and sweet, because I know you're a busy man. I'm here pleading not guilty to the parking citation on the date in question. I was operating a golf cart, which I do not own. It was there at that rental property to transport 3 elderly individuals who are legally registered handicap placard holders in the state of Alabama. It is my understanding that handicap parking privileges follow the disabled individual and not the vehicle. However, we didn't hang the placard on the golf cart because it's an open vehicle and we were afraid it could blow away or someone could steal it. I did not park. I unloaded the ladies there and all the items that we had to go down to the beach. We did rent, since it was a handicap beach, we did rent umbrellas and the chairs from the vendor that's there every day. And I had to help them, especially Sylvia, to get down to the beach because of her inability to walk. I used a designated handicap space strictly to safely unload these passengers and their mobility gear at the beach access point. The placards were not physically hung on the golf cart due to the immediate risk of death, theft, or high winds. I provided the copies of the placards to you, Your Honor, and to the county. I returned to the cart as quickly as I possibly could. There was other open handicap parking areas that were open, and I did not find a ticket when I got back, as the officer said. And I'm sure it was because it could get blown away or whatever. But and I moved to a parking spot which was way down the road. There's very little parking at that handicap place, and it was a really nice. We had a really good time. We had a great time, but. Your Honor, this is why I'm pleading not guilty, that I didn't park there. I just unloaded, and due to the helping the ladies get to the beach to meet with the vendor, my wife stayed there with them to get the stuff set up, and then I proceeded back to the cart and moved it.
Okay. Thank you, sir. And I keep these, it's
Yes.
gonna be put in, okay,
Yes.
so we'll, county got any issues, I'm gonna go ahead and accept this into evidence from, Mr. Brown at this time. Do you have any questions for Mr. Brown, Officer Knudsen? Okay. All right, Mr. Brown, you can grab a seat. Is there anything else from the county on this? Okay. Well, let me ask you this, Was the reason that you did not put the citation on the low-speed vehicle, was that due to wind or anything, or was that just
Your
because he
Honor,
had
it
left
was
the
after he
area?
had left, so I sent it.
So you're
certified
writing
mail.
the citation?
Yes, sir.
And then he had loaded up and left? Okay, so, and is it, I mean, it makes a good point, right? Like hanging those out, I guess somebody could steal them if they wanted to, or just to mess with them, you know, take them and throw them in the garbage or whatever. I mean, but I also see the flip side, you know, we need to know whether or not the occupants of that low-speed vehicle have proper credentials to park in those spots. I mean, so they just kind of hang them or set them in
I've
the,
actually spoken with people in the past. I've had them leave them just in a visible area where I can see them, since the LSV is an open vehicle. It'd be easy if they set it on the dash or in the little compartment on the front of the LSV.
yeah, just, I mean, I get it in a enclosed vehicle, you know, right? It's protected. I mean, I guess if they really wanted to get at it, they could break your window and get in there, but I can understand Mr. Brown's concerns regarding leaving something like that out there. All right, anything else?
No, Your Honor.
All right, Mr. Brown, do you have any other questions based on my questions to the county? I asked her a couple things. I don't know if you want to have any follow-up.
There was no safe area to park, unload all the items that had to go down to the beach, and then also help free elderly individuals.
Understood.
We felt like that was the safest place to unload, digging down. I did get back as soon as I could. I couldn't get down there for more than 8 minutes, 10 minutes.
Okay.
Help with any consideration.
Understood. Yes, sir. All right.
We love Florida. We like to come down here. Always have a whole lot.
All right, thank you, sir. All right, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find, based on the testimony and evidence presented, that there is sufficient evidence to show that a violation had occurred, specifically a violation of 20-21, handicap parking, for failure to display a placard. I do find that, based on the evidence presented and the uncontroverted testimony, that Mr. Brown appeared to be helping some elderly guests to enjoy Walton County beaches. However, there is a requirement, to the best of your ability, to present those placards so we know, even if it's for a short time. I don't find the argument persuasive that, hey, we were only there 10 minutes or we were only there 5 minutes. I mean, you know, there's no way to know that until it happens, and then, you know, there is no carve-out in the statute that I'm aware of that says as long as they're there 5 minutes or less, they can park there. So with that having been said, I do find a violation. The regular fine and penalty would be $250. I'm going to reduce that to $100. There is a $50 administrative fee that will have to be paid, so the total will be $150 instead of the $300 that would normally be imposed on this. Mr. Brown, can you pay that within 30 days? Okay. I'm going to order that be paid within 30 days. As I've told others, you can't pay that right this second, but you can pay it probably by this afternoon, and that can be paid at the Walton County Clerk's office. All right?
Your Honor, may I be excused?
Yes, ma'am, you may be
Thank you.
excused. Thank you. And Mr. Brown, you're excused as well. Thank you. Our next case is Yana Wells, case number 26-1330. And the citation is for improper parking. And we have Officer Lemon on that case. Is Officer Lemon here? Okay, I don't have that. Is Miss Wells here? I'm assuming it's a miss. We don't have Miss Wells or Officer Lemon? Okay. And when was this continued? Who requested the continuance? Okay. I know the clerk's out of sorts because she didn't have her computer right this second. So, all right, was this continued to the next, in September? Okay. All right, at this time, we'll go ahead and continue case number 261330, Yana Wells, to September 9th. All right, and then number 9, Stephanie Samuels. I show that was resolved or taken care of, paid prior to today's hearing, so we'll skip that. That brings us to Sampson Thomas, and Mr. Thomas is on the next 5 matters, and I know he's represented by legal counsel, Mr. Roberts.
We may be real quick if you entertain.
Yeah, I was going to ask how the parties wanted to kind of proceed. I mean, normally we would take these each individually, different dates, different times, you know, different facts.
Go ahead, if you're okay. Yes, sir. So each of these things involve
Come on
the
up.
exact.
Yeah, just so we got, go ahead.
The exact same thing, and it's vending on a portion of the wet sand.
Okay.
Based on your previous ruling, my client will stipulate to the fact that he was vending on the wet sand, and then we'll have to take the issue up to the court or to the circuit court.
Okay, so,
That will resolve all 5.
well, and I mean, I think the issue, and you know, you've been an attorney long enough, you probably want to make your record, right?
I think it's a simple question of if he wants to put him on there and say, did you do it? He did it. And then the simple question for the court to resolve is whether or not the wet sand is there. I'm happy
Okay,
to put on the-
right,
take the
I mean,
record.
I'm not gonna tell you how to build your record for an appeal, but if your plan is to seek an appeal, which is fine, you know, that's your right.
And I don't want you to.
And I
get
mean,
notified.
then you get, you know, I want you to make sure you got a record sufficient, both the county as you.
How about this? We won't belabor the point. We'll admit to the fact, and then he can make his, and we'll make ours, and ours will be very brief.
Okay,
And
however
we
you
take all
wanna
5 at
present,
once
I
and
just wanna,
stipulate.
I wanna give, you know, everybody the
Yeah, I
chance
don't
to
wanna take away
present,
from
you know,
it,
get
but-
their record.
Yes, sir. No, we're
just
we're
trying to
doing
save
all
both
5
sides.
cases at the same time.
Okay, so we'll agree, I guess, kind of as ground rules for case number 260832 against Mr. Thomas, case number 260833, 261471, 26812, and 261364. As I stated, they're all against citations against Mr. Sampson Thomas. Let me ask this, is the county going to stipulate or concede that that Mr. Thomas was, the actions that he was doing where he was vending on the beach, were they completely on the wet sands or were any portion on the, I guess, dry sand or above the mean high water line?
So technically, Your Honor, he was vending. We would consider it the beach because he's there, but he is where the water is flowing and off and on the beach.
Okay. And then, so I think that's kind of the main thing that Mr. Roberts, but I'll allow the county to present, you know, any testimony or evidence to
Yes,
build
sir.
the record. And then I'll give Mr. Roberts and his client the opportunity because, you know, the court
Yes, sir.
at that stage is going to look at what's in the record and what's been brought up. So
Yes, sir.
at this time, if county is ready to proceed and Mr. Roberts, you're ready to proceed? Okay. All right, Officer Cannon, are you going to be presenting for, because I have 2 citations for you, but then I have also 3 citations issued by Officer Guard.
Yes, sir. I'm presenting all 5 cases.
Is Officer Guard here?
Yes, sir. He is present.
Okay. I will say, if there's anything specific that Officer Guard witnessed, I'd want to hear from him on that, right?
Yes, sir.
Like just so he's,
Right, yes, sir.
if he was a firsthand witness. But we'll go ahead and let you proceed, Officer Cannon. And if
Yes,
we
sir.
get to that point where we think we need to hear from Officer Guard, we can call him up, but he is present to testify if needed.
Yes, sir.
All right, go ahead.
All right. So we have issued a number of citations to Sampson Thomas for vending on the beach without a permit. He has made no attempt to obtain a county permit for vending on the beaches. Let's see, dates in question, we wrote a citation on April 30th, May 4th, May the 5th, June 10th, and June 12th. Then we had our original court date last month. Since then, we have written, I believe, 7 more citations. Every time we have approached Mr. Sampson on the beach for vending without a permit, he has been cooperative to a degree. He signs for the citations and accepts them. We did have to have the Walton County Sheriff's Department out for the first offense to get his information on record. That's pretty much it. He's admitted to vending on the beach without a permit. I have evidence if I'd like to present to the court and to the complainant.
Okay. All right. I've been handed I guess this is
our packet.
Yeah, your packet showing the vendor citations 1, 2, 3, 4, 5 with dates of April 30th, May 4th, May 5th, June 10th, and June 12th against Mr. Sampson, and then also, I guess, sections of the code that are alleged to be in violation, 22-60B, sub D, sub E, and 22-54, sub E. I see a narrative in here for you, Mr. Cannon. I also see a narrative in here for Mr. Guard, or Officer Guard, rather. Officer Guard, can you come up? Have you seen these narratives that are in this this packet that was presented by Officer Cannon?
Yes, sir.
Okay. Have you reviewed those, and are these accurate reflections of what you did as it relates to the citations that were issued by you personally?
Yes, they were.
Okay. Nothing to add or nothing to change necessarily at this time?
No, sir.
Okay. Thank you, sir. You can grab a seat. Oh, sure. Yeah, go ahead.
Did you hear?
Yes, sir.
Is that your recollection? That's all I need from him, Your Honor. Thank you.
Sure.
Thank you.
And then I have a copy of what appears to be all the citations that we are here for this morning.
Yes, sir.
A photograph of, I believe that may be Mr. Sampson.
Yes, sir.
And that's his vending cart?
Yes, sir.
Okay.
And then the last 3 pages are a printout of a citation tracker that I made, tracking how many citations he's been issued and what they've been issued for.
Okay, so this is something that you've self-created to
Yes, sir.
track, I guess, Mr. Sampson and his activities on the beach?
Yes, sir.
All right. So does this matrix or printout this just for the citations today, or are there other citations? I
Other
see,
citations on here.
I do
as of-
see 9th, 10th, 11th through like
I believe we've written
14.
12 citations now.
Okay, 16, all right. I will say for purposes of today, we only have the 5.
Yes, sir.
Regardless of whether or not other citations may be in the pipeline or not. Do you, all right. So are there any objections to me accepting this, Mr. Roberts? Okay, so I'll go ahead and accept this packet presented by the county into evidence. Is there anything else that the county wishes to present this morning? And that would be on any of these citations. I know we're trying, for expediency's sake, trying to get everything together, so.
No, sir, Your Honor. The only thing the county would like to state is that the matrix was added just to show a pattern that he has continued to vend, even though we asked him to stop vending until this case can be heard in court.
Understood. And just so I'm clear, like the photograph that you provided,
Yes, sir.
is this a scenario where he's in the water during all these citations, or are there times, because like in this photograph,
Yes, sir.
I can see he's well within the water, right? The people, at least these individuals, are ankle deep. Now this gentleman is not necessarily in the water at this point. I don't know what the wave action looks like or is happening there, but
And
is Mr. Sampson always like in the water part, or is he also kind of up here, or would this like the water recede and he would sometimes be on the wet sand? I'm just trying to.
yes, sir. So in that particular photograph, the water had just washed up. He is at points where he's not in water; he's on the wet sand.
Now,
we do have body cam footage of our interactions if you want to see those.
I mean, if the county wants to present that, I don't know that Mr. Roberts is arguing that the body cam footage will show what it shows.
Yes, sir.
Is that correct? That's right. Okay. So, I mean, I don't mind accepting the body cam footage into evidence for the county's purpose, and I don't necessarily need to review it if there's no argument that it just shows what it shows, correct?
I don't see any problem with it. I mean,
Okay.
at this point, the photos are fairly clear, and I think they tell the story. The size would be.
All right, well, I'll allow the county if it wants to, with the understanding, it appears Mr. Roberts is gonna try to get the circuit court to clear this up for all of us. We'll go ahead and accept the body cam footage into evidence,
Yes, sir.
today, but we won't necessarily need to show that. You'll need to make sure that, give that to the clerk right now so she has that. The,
Connor, I assume I can get a copy of it at some point.
yeah, you should be able to. Will code just provide that, or you want to try to get that from the
So
county?
we can provide a copy.
Okay, so yeah, just get with code.
Yeah, they'll have to, because we can't put it in any of our equipment.
Okay, I was just informed by the clerk, you need to get it from code, because they can't put it on there.
Yeah, we'll get you.
We have a good relationship.
Yeah.
I'll
Good.
pick up the phone.
All right,
Or I'll call the attorney. I'm sorry, I probably won't.
What we will do is we'll go ahead and make a copy.
okay, excellent. All right, so we have the packet, we also have and they're going to make a copy of that thumb drive for you, hopefully in somewhat real time. Is there anything else, any testimony or evidence that the county wants to go ahead and put on the record at this time? Testimony?
Good to go.
Okay. Mr. Roberts, do you have any questions either from Officer Cannon or Officer Guard? I know you asked an earlier question, but if you have any more.
I think they both testified that it happened in the wet sand at a minimum, and sometimes in the water. That's fine for my purpose. I just want to make sure the court can resolve the issue of whether or not the wet sand is something that the county has authority to regulate. That's going to be the only issue.
Okay.
And I'll clear it up for everybody, hopefully, so we won't have to have these hearings anymore
Yeah,
about it.
I appreciate that. All right, anything else from you, Mr. Roberts, as far as evidence, or if your client, if you want to have your client testify on
Yeah,
any
I'd like
part
to
of it?
just give it will be ever so brief.
Okay, so Officer Cannon,
Oh, hold on.
Oh, I'm
Your
sorry.
Honor, I'm sorry.
wait a second. Hold on, if you want to come up and identify yourself.
So Frank Larkins, Beach Code Compliance Manager. Just for the record, I just wanted to make the point that I know we also have witnessed them venting on the dry sand just as well. So I know we're not solely speaking of wet sand.
Well, and I guess that would be
Just to
my
your
question.
question,
Are any of these allegations that he was just on the dry sand? I think we would have to treat that a little different. But if
Okay.
we're going to concede that every one of these 5 violations that I'm here for today all occurred on the wet sand side, then I think Mr. Roberts is willing to say, hey,
Yeah.
we'll agree to that set of facts, and our plan is to appeal to see if there's maybe a gap in the county's code. But if you're saying, no, one of these was just dry sand only, then I think we need to treat that one maybe a little different.
Yes, sir.
Okay, so
Yeah, it
are
was
there?
just response to your question.
Yeah, and I appreciate that. So for everybody's sake, are any of the ones that we're dealing with or that are on the agenda this morning dealing with allegations that Mr. Thomas was vending on the dry sand when he was seen or cited?
Yes, sir. So for these 5 citations, he was in the considered wet sand for all of these citations.
Okay, great. So I think we can treat these as different than maybe a dry sand citation. Okay. All right, thank you, sir.
I
All
have
right.
some very brief questions for my client, just to
Yeah.
make sure I pack the record in.
Yeah, good. All right. Officer Cannon, you can grab a seat. Mr. Roberts, whenever you're ready.
I don't know if you were sworn in. I just want to make sure he's on the
Okay,
record.
go ahead, raise your right hand, sir. Mr. Thomas, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, if you would, come by the microphone, maybe jump on the other side of Mr. Roberts, and then I'll allow Mr. Roberts whenever you're ready.
Thank you, Your Honor. Just want to nail down a couple of points. When you go out, or you don't contest the idea that you go out to the beach to vend ice cream, is that correct? And you do it every day? Yeah. Okay. And in doing so, do you traverse across the sandy beach onto the wet beach and set up?
No, they have signs saying where they own, saying do not trespass. It might look like I'm on the sandy beach, but it's all hard. My tires will flopple if I try to go any higher. So I stay on the hard, wet sand always, making sure that the signs are way up there and the umbrellas are way up there. Don't go past any of it. So anything that they say they do, it must be a mistake.
Okay. And you don't contest the fact that you're out there selling ice cream on a regular basis?
Yes, sir.
All right. And do you always vend in the wet sand?
Always.
And never in the dry or
Never
the
in the
soft sand beach?
Never in the soft sand. Never.
All right. And it's your opinion that you have a loophole in the code that says that you're allowed to vend in that particular property?
Yes, sir.
All right. And is it your intent to continue doing that?
Yes, sir.
All right. Your Honor, that's all the record I need to make my point.
All right, thank you, sir.
Thank you.
Real quick, County, do you have any questions for Mr. Thomas? Okay, go ahead.
Just to state the record clear, you have to walk across the sand to get down to where did you say you're vending?
Yes,
Is that
sir.
correct? All right. That's
I take not your public beach access.
still has to walk across the beach, correct?
Not anywhere near where you own are allowed to regulate.
Where do you enter the beach at?
Panama City area. Way off from where you are. Walks 12 miles a day, every day, 7 days a week.
Still has to walk across the beach, all right? Got it.
All right, anything else, Mr. Roberts?
No, I think that will take the question up, and we'll let somebody make a decision on it.
Okay,
I
thank you,
go
sir.
through state parks, and I come down through Panama and state parks. I don't go anywhere near their public beach access, and they'll never see me do that.
Thank you, Your Honor.
All right. All right, anything else? I believe Mr. Roberts has done. Anything else from the county? All right. What I'm going to do is I've done, we had 5 separate orders. I asked the clerk just to do kind of one master order to deal with. That way, whenever Mr. Roberts takes this up on appeal, he'll just have the one order versus 5 individual ones. All right, at this time, I'll go ahead and close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that based on the evidence presented and based on my prior ruling, I do believe that the county has the authority to regulate that portion of the wet sand. But I understand Mr. Roberts' client's argument that the county doesn't. So I'm looking forward to seeing what the circuit court decides on that. We've had a couple of cases, this being some of them, so it may require the county to amend its ordinance, or it may require no amendment. So we'll all see. I'm going to put in here 60 days to pay this, and for the record, this imposes a $500 fine times 5, so that'd be $2,500. A clerk administrative fee of $50 times 5, so that's $250, and a clerk processing fee previously assessed, and that's on each citation of $25, so that's $125 for a grand total of $2,875. Based on the amount and understanding what Mr. Roberts' plans are, I'm going to order that be paid within 60 days. Obviously, that may not get paid while the appeal's pending, but I'll sign that order, and that'll conclude those 5 cases. And Mr. Roberts, you received a copy. And we've got, and just so we're clear, there's no physical evidence or anything that you wanted to present into the record. All right. Thank you all. Best of luck. I look forward to seeing what the outcome is. Something from the county? Oh, yes, sir. Yes, please. Yeah, anybody else, if you've already handled your case, don't feel like you have to stick around. Who, Brooke? Brooke Davis? Or not? Oh, yeah, she's not an attorney. Yeah, she's not an attorney. All right, we only have 2 left, so we're gonna just keep plugging through at this point. We've got 30A golf carts. The interested party is listed as Brent Peterson. That's case number 26-1400. And we have Officer Knudsen on that case. Is anybody here? Is Mr. Peterson here, Brent Peterson, on behalf of 30A golf carts? All right. Is Officer Knudsen here? Oh. Oh, so, well, maybe that's why nobody here for, all right, so that was continued to September? All right, so we don't have anybody here on that case for 30A golf carts. All right, so we'll continue that matter to September 9th. And then the last case then is Mr. Curtis Winter, case number 26-1426. And then we have Officer Esquivel. Has that one been continued? Because I don't see Officer Esquivel or Mr. Winter. Is that one supposed to have been continued, or? Huh?
I'm asking.
Okay. And anyone who's here for the code compliance hearing meetings, we'll start those. We'll take about a 5-minute comfort break, and then we'll start those immediately. Okay. Well, is the county asking that it be continued? Okay, to September 9th? All right, I'll grant that continuance to that date. All right, that appears to conclude our magistrate docket. If there's nothing else, we'll adjourn on that. And we have the code compliance hearing meeting. Let's start that at about 10:40. We'll start that in about 5 minutes. So 10:45, we'll reconvene that. All right, so at this time, we're on a brief recess. right, I'm going to call to order the code compliance hearing meeting, hearing for August 12th, 2026. It's 10:47 a.m. At this time, if you have a phone, please turn it off or put it on vibrate. My name is Hayward Dykes. I'm the special magistrate. If you will please stand with me, we will do the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Grab a seat. I reviewed the minutes. I've signed those. Are there any announcements regarding the agenda? I show that number 5, number 7 have been resolved. Is that still the case, correct? Yes. All right, so that would be Castillo, case number 26213, and Barsky 26303. So those are off. And then I have the matter in Desert Retreat LLC, case 260322. That one's been extended until further notice. Okay. So I'll take that off. Are there any other announcements or any other updates on the agenda that need to be made? Yes, sir. Okay, thank you. Right, at this time, I don't know who was here for the last go-round, but just in case, if you have not been sworn in but plan to present testimony or evidence, if you'll stand, I'll go ahead and swear everybody in at one time. Raise your right hand. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you all. So our first case is beach permit BCHV 260051. Vendor is Beach Bonfires 30A, and its representative is Caitlin Arnett. Do we have Miss Arnett here? Or somebody else maybe for Beach Bonfires 30A? Okay. Do we have a representative for the county on this? All right. Come on up. And what's your name?
Christopher Zorn.
All right, Officer Zorn. How do you spell that?
Z as in zebra, ORN as in November.
Okay. All right, Officer Zorn. Are you ready? Is the county ready to proceed on this case?
Yes, sir.
All right. Whenever you're ready, go ahead.
I'm going to read from my case narrative. On 6/10/26, at approximately 8:24 a.m., I observed the remnants from a certain bonfire located at Inlet Beach Regional Beach Access, number 3A. The remnants were located approximately 60 feet south from the wooden beach access and consisted of 2 burnt wooden logs. Upon further investigation, utilizing my field maps application on my department-issued iPhone, I determined the location to be the same location as a bonfire permit number 84145. set up by Beach Bonfires 30A. I took pictures of the remnants with my department-issued iPhone and recorded the removal of the burnt logs via my department-issued body camera, number N79713. And I subsequently issued a citation on the same date, citation number CE001455, to Beach Bonfires 30A for 2254B1E, due to the 2 burnt logs discovered upon my investigation.
All right. Is there any evidence that you wish to present at this time?
Yes, sir.
All right. All right. Thank you, sir. I've been handed looks like I've got 2 in here. Am I supposed to get both of these?
Yes, sir. So there's previous citations as well from other cases.
Okay.
And the 2 previous cases were 5-point violations each, and mine was a 25-point violation.
All right, so based on the point system imposed by the county ordinances, this violation would incur a 25-point Is that what you're saying?
35,
Or,
yeah.
I'm sorry,
My
35.
final citation is 25, totaling 35 points for a 10-day suspension.
Okay. So I have printouts and information related to a February violation, that's 260712.
Yes, sir.
A June 10th or June 8th violation, case number 2604943, and then a June 10th violation for case 2604966.
Yes, sir.
Are any of which one would be for this one that's 260051?
They're all for the same beach permit.
Okay. So these are, I guess what I'm asking, are any of these the printouts from your geolocation of the bonfire and checking
Yes,
whose
sir.
permit it was? Which one is that? I just want to make sure.
Mine, it would be the 2604966. Should have a location marker of where the fire was and where I found the fire.
So these are the two logs that you say you found?
Yes, sir.
Okay. All right. I'll accept the packet into evidence. What's the county requesting?
We're requesting 48 hours for the penalty to take effect for the 10-day suspension.
All right, so that would have it starting on August 14th or August 15th? It'd be 14th, correct?
Yes, sir.
Okay. And at what time? No, would that be 12 a.m., 12:01 a.m., or how do you guys normally try to do
It
that?
says in our policies, the end of court proceedings.
And just so the record's clear, this is unlike the other matters where we hear it, this is an appeal related to the suspension component if found in violation of the underlying charge. So this was basically a request to say either the suspension should not be imposed or the points not be imposed. So, all right, anything else from the county?
No, sir.
All right, thank you, sir. I'll close the evidence portion of this hearing. I'll find that based on the testimony and evidence that the appeal requested by Beach Bonfires 30A will be denied, and order that the suspension, 10-day suspension, begin within 48 hours of today's court proceedings. Is that how you
Yes,
guys?
sir.
Okay.
End of business today.
End of business today. So within 48 hours of end of business today, the 10-day suspension will begin for 10 consecutive days. Do you guys have an order that I need to sign, or do y'all just note that in your system?
Yeah, we'll just notate it.
Okay. You may want to, maybe in the future, just do like a simple order, just saying, 10 days and then, starting on this date. That way, there's a record of it, or at least, something in writing you can give if somebody asks for it. All right?
Absolutely. Yes, sir.
All right. Thank you, sir. Next case is CESTR, case number 260083. Property owner is listed as Sonia Smith. Address is 11 Driftwood Road, number 5, Miramar Beach, Florida. Are you Miss Smith? Okay, thank you. So Ms. Smith, what we'll do, I know you've been here a little while. We'll allow the county to present. I'll allow you to ask any questions, and then I'll take any testimony or evidence you may have. All right? All right, thank you, ma'am. And is the county ready to proceed?
Yes,
All
sir,
right,
may I
and
approach?
Ms. Smith, are you ready to proceed? Yes. Okay, thank you. You don't have to keep standing up. I just want to make sure. All right. Whenever you're ready. Yep. Okay. And a copy of this has been given to Ms. Smith? Okay, thank you.
Good morning. My name is Officer Justin Sloan with Walton County Code Compliance. This property is located at 11 Driftwood Road, Unit 5, Miramar Beach. Parcel ID is 30-2S-21-42520-000-00050. This case was presented to the magistrate on April 8th, 2026 at the short-term rental hearing. It was ordered that the property gain compliance on or before April 10th, 2026, at which point a $500 per day fine shall accrue. This property gained compliance on May 8th, 2026. This equates to 28 days of noncompliance, resulting in a $14,000 fine. In your packet, you will find an order of fine reduction as well as copies of the signed final order, order imposing fine, and the affidavits of noncompliance and compliance. The property owner was offered the county's mitigation program to reduce the fines to 10%. However, she has declined to participate. Administrative fees for this fine reduction are $50. In this case, the property is income producing and not a homestead. A review of the enforcement record further reflects that the county adhered to all applicable statutory and procedural requirements throughout the processing of this matter. Proper notice was provided, and there are no administrative errors on the part of the county. Based on the evidence and adherence to due process requirements, the county recommends no fine reduction. If a fine reduction is ordered, the county recommends that the reduced fine and associated fees are paid within 30 days of the signed order, or the fine will be reinstated to the original amount ordered.
I'm not going to call it an amnesty program, but whatever that program
Mitigation
is that
program?
still mitigation program?
Yes, sir.
Is that still in effect, or has that ended? Because I
It's still in
understand
effect, yes, sir.
It's kind of like a pilot program. All right, and so this is just a fine reduction hearing. All right, anything else from the county at this time?
No, sir.
Okay. Ms. Smith, do you have any questions for Officer Sloan at this time? Okay, sure, come on up.
I don't know what this is, NOV and NOH, the certified mailings. I never received an email either. I just got the notice. My housekeeping didn't even tell me it was on the door, laminated, taped.
Give me 1 second.
Sure.
So on April 30th, I spoke with the property owner, Ms. Smith, who stated she was not getting notices. I confirmed her address was correct on waltonpa.com and told her all correspondence were sent to this address. And then I gave her the number to the SDR office so she could call to see what was needed from her.
Thank you. So does that mean that if I spoke to you on the 30th, I received your laminate notification on the 29th or 28th? Do you know when that laminate was put on all the houses in our complex?
I can see. So on March 13th, I posted a notice of violation and notice of hearing at the property and at the South End Courthouse. And on March 2nd, an NOV and NOH were sent to the property owner via certified mail.
And those are March, and so I never received those. Okay, 9th. And that NOV and NOH, do you know what that stands for?
It's a notice of violation and a notice of hearing.
Okay, all right. So it seems that if you posted those on March 13th and I called you on the 30th, there was a 15-day lapse. Spoke, and I know we did speak, and I know we texted, so thank you for that. I appreciate you. And this, Your Honor, is I'm actually glad to see that we're doing this because we did the balcony inspections. You know, that protects us from the whole Miami fiasco. So I don't want to buck the system. I just wanted to plead my case, if you don't mind. There you are, Justin. So, may I
Yeah,
speak
if
on
you
my
have more,
behalf now?
yeah, and if you're done with Officer Sloan, I'll allow you to present it. And just so we're clear, I mean, we're not going to relitigate the case,
Right.
but we are going to, I'll take anything that you want me to consider to mitigation, for mitigation of the fines. So at this point, as far as my role, it's not to, hey, everybody come back and we're going to do a do-over. It's more of, hey, what do you want me to consider, or what should I know that would say, hey, this $14,000 fine should be reduced to X number or to 0, and this is why I think that's important. But if you have any other questions for Officer Sloan, I want to give you that opportunity to ask those, and then I'll obviously let you present whatever you want.
I have one more, I guess,
Sure.
last question, because it looks like you texted me, on March 24th. Okay, so I send a please text me if I'm on the other line usually.
Yeah.
So you texted me, and then on July 7th, we talked about this, the hearing. So March 24th, you said you sent the certifieds on March 9th. There seems to be some sort of a lapse of time. And I think that's pretty much all I needed to clarify. Can we get a notification on the certifieds being signed for? Because I didn't,
Yes, ma'am, I can get you a copy of it, yeah.
because they're supposed to be forwarded to my PO box, and I don't recall having those in there. So,
I mean, I can get you a copy of it.
yeah,
sent,
if you
yes,
don't
ma'am.
mind, I was just curious, because I'm like, how did I miss this? How did I miss the emails?
I'll send it to you.
Thank you. Okay, so I don't do it again.
Yes, ma'am.
Okay.
All right, anything else for Officer Sloan? All right, if no other questions for Officer Sloan, I'll allow him to grab a seat. And then Ms. Smith, again, I'll glad to hear, don't necessarily want to relitigate the issue. Sounds like there might have been some questions on notice, but, to short circuit some of that, you're here for a fine reduction. The current fine as testified by Officer Sloan is $14,000. What are you asking me to consider as far as a fine reduction? And then, so I'll hear anything related to that.
Okay, thank you, Your Honor. Thanks for your time today. Just a little background. I have, my mom has Alzheimer's, and I've been given power of attorney, medical and durable. And that was since Alzheimer's is 2024. Her dementia was 2016, so we've been dealing with it for 10 years. For the past 2 years, we've been trying to put her on hospice. So we finally got her on hospice June of this year. So this is all kind of coming in the March, April, May, and finally we got her on hospice. So we're getting a little bit better care. But I wanted to also leave you for your records, if you need it, the durable power of attorney for her, some of her medical appointments, and those are quite timely for a job that I didn't really sign up for, but that's what we do. Since I do have all my licensure and my DBPR, Department of Business Regulation, I keep up to as much as I can possible. In fact, going through some research with this, I found I have some licensure I don't really need to have, so I'm paying in other areas I don't need. Also during this, I've been hospitalized before the 2024, so there's been a lot going on with financial and medical, and then I have a minor under the roof. I'm a single mom. Don't get child support. That's not what we're here about, but I would like to ask for a dismissal of the fine. This will never happen again. This is a one-time event. I try to be, above the law and support the law, and if you'd have mercy on us, I would greatly appreciate it while we deal with my mom's demise.
Okay. So your request is to reduce the fine to 0? Is that correct?
Yes. As soon as I was aware of this, and I took care of it, got the balcony inspection on May 11th, I think it is. Yes, sir. I took care of it as soon as I was aware and made good. I had a hard time finding a balcony inspector, but I did find somebody.
This isn't related to the balcony inspection, correct?
No, but it's a protocol that they have.
Yeah, I mean, I think there's got to be some inspection of the premises, but, okay. All right, and I was just trying to figure out how that was relevant, but you're saying you had to
Time-wise.
get the inspection so you could get the proper
To follow the
license
rules.
and permitting, right?
Yes, sir.
Okay. All right. And anything else, Ms. Smith, that you want me to consider?
No, just that, it's overwhelming taking care of a parent and having a minor, and, it's unfortunate, and I will never let it happen again.
And is this property used for rental?
Yes.
Okay, so it is income producing, all right. Anything else? Let me ask this, is there anything the county has that they wish to ask Ms. Smith about? Okay. And Ms. Smith, is there, I'll give you last word, is there anything else that you want me to consider?
I'm trying to keep it as concise as possible. I think you have my word, it won't happen again.
Okay. Appreciate that. All right, thank you, ma'am.
Thank you for your time.
All right, at this time, I'll go ahead and close the evidence portion of this hearing. And I'll find, based on the testimony and evidence and the request made, that a fine reduction in this case would be appropriate. I will not be able to honor Ms. Smith's request to reduce the fine to 0. As stated, there was a violation. She's essentially admitted the violation. I know she wasn't able, or maybe were some issues with the notice, but I haven't heard anything today to suggest that the notice was legally deficient. And because of that, I do think there needs to be a fine. I don't think $14,000 necessarily would be appropriate based on the facts and evidence at this point. But I will order that the fine will be reduced to $1,000. Now, I will advise you, Ms. Smith, that that amount will need to be paid within a time certain, and if you fail to pay it within that amount of time, it will automatically be reinstated to the full amount of $14,000. So, with that being said, can you make that $1,000 payment of the reduced fine within 30 days? Okay. So I'm going to order that be paid within 30 days. All right. And so you'll have till September the 11th to pay that. There is a $50 administrative fee that will also be paid. That's separate from the fine reduction. So essentially $1,050. I'll order that both of those be paid within 50 days. And as I said, just be aware, if you fail to pay it, that the full amount will be reinstated automatically. So do you have any questions regarding that? All right. Best of luck to you, ma'am. Sounds like you have a lot on your plate. So unless there's anything further, we'll go ahead and that'll conclude that case. And you're dismissed. All right, our next case is CE 26-0272. Property owner is listed as Small Serenity LLC. The address is 159 Driftwood Road in Miramar Beach. And are you here on behalf of Small Serenity, sir? Okay, and what's your name? I'm sorry?
Chris Avery. Oh, sorry, do you want me
Yeah, Avery?
Yes, Avery.
All right. All right, Mr. Avery, we'll handle this one just like we did the last one, allow the county to present. You can ask questions, and then I'll let you present any evidence or testimony you want me to consider. All right?
Appreciate it, sir.
Yes, sir. Yeah, you can grab a seat right there for now. And then if you decide you need to ask questions, then I'd ask you to come on up. All right. I assume, Mr. Avery, you're ready to proceed. Is the county ready to proceed?
Yes, sir.
Okay. That being the case, whenever you're ready.
Good morning. My name is Officer Uriel Basel with Walton County Code Compliance. For the record, I am submitting my final summary case report and testimony regarding case number CE-26-00272. May I approach?
Yes, sir. Thank you, sir. And I have a packet from the county, which appears to be kind of the standard packet of information regarding notices and photographs. Mr. Avery, or I'm sorry, Officer Basil, did you provide Mr. Avery a copy of this?
Yes, sir.
Mr. Avery, you've got a copy? All right. All right, I'll accept that into evidence at this time, and you can proceed, Mr. Officer Basil.
This property is located at 159 Driftwood Road in Miramar Beach, Florida, 32550. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7. Violations cited are 1.13.00A, development approvals, 1.13.09C, building permit, and 5.01.10, fences and hedge walls. We received a complaint on April 21st, 2026 for unpermitted renovation and illegal conversion. An initial inspection was conducted at address 159 Driftwood Road in Miramar Beach on April 21st, 2026. The property is fenced in with a privacy fence that requires a passcode to enter the property. The property has pavers designed as a parking lot for approximately 10 vehicles near the road. Further research conducted found the property was recently sold as a 5-unit rental income producing property. Photos obtained from the new and old listing of the house reveal large renovations and alterations made to the interior and exterior of the unit/building without the proper approvals and permits from the planning and building departments. On April 30th, 2026, a notice of violation was sent certified mail and posted at the property. Contact was made with the current property owner and the previous property owner to discuss the violations and corrective actions required to bring the property into compliance. The property owner was able to correct the fence violation by removing a portion of the fence out of the front setback, satisfying the fence violation. The property owner was also able to obtain an after-the-fact permit for the windows, doors, and siding from the building department, where an extension was provided due to the property's owner's efforts to bring the property into compliance. On June 17th, 2026, a pre-application meeting was held with the planning department regarding the property and its violations. On June 22nd, 2026, I received an email from the planning department informing me that the property does not have the permits to change the single-family property to a multi-unit property, much less a 5-unit. The provided option given was to revert the structure back to a single-family dwelling or to request a future land use/zoning map amendment and then a development order. Establishing status of the 5-unit halted the progression of the case. On July 15, 2026, a notice of hearing was sent certified mail, and on July 21st, 2026, was also posted at the property and the South Walton Courthouse. A meeting was held yesterday where parties from the Planning Department and Code Compliance Department met with the property owner. Non-conforming use was established due to new evidence obtained and show a combined duplex prior to 1996. Photos in your packet show the initial inspection, photos and the pre-hearing conditions with violations 1.13.00A and 1.13.09C still existing. I'd like to submit my packet into evidence.
All right, that'll be accepted into evidence. So just so I'm clear, it looks like the August 11th update in your code case detailed report on this, it was determined that the 5-unit status is non-conforming since evidence from the property appraisal site and Google Images appear to support that idea?
Yes, sir.
Okay. And that was, those decisions were made by planning, correct?
Correct.
All right.
Yeah, they were made yesterday, and that will allow the property owner to continue his application. So what ended up happening is just determining whether it was a 5-unit or not was kind of halting the progression on it. once they established that yesterday, he can continue. There still are alterations made to the exterior and interior of the building that need to be corrected, but this will allow him to continue that process with the building plan review application to get that hopefully in compliance.
Okay, and then I think you've already stated, so we're not dealing with the fences, we're just dealing with 1.13.00A and 1.1309 sub C permitting.
Yes, sir.
Okay. And are there currently, to your knowledge, Officer Baza, whether any future meetings or what would be next steps for the applicant?
Yeah, the next steps we discussed yesterday and they have an engineer already working on it to create or develop maybe a plan for their stormwater and all that, because all that has been altered. We discussed the building permit. They said they reached out to the building permit because looking at the photos, it does appear that they've done some alterations to some plumbing and electrical. Typically, we require a building permit for that. I think they said that they discussed that with the building department, and they told them that they would allow what they've done. So I just need something in writing from the building department regarding that.
All right. Mr. Avery, do you have any questions for Officer Baza at this time? Okay, if you want to come on up, I'll hear anything that you wish for me to consider, or if you have any evidence that you want me to take in, we can do that at this time.
Thank you, Your Honor. No, basically, we would just like to ask the court for 90 days for corrective actions with the plan that we've outlined. As mentioned, we have an engineer on site. We're coming up with a stormwater mitigation plan. We would have enacted that sooner, but the planning department said, look, until we get this completed, halt that for a minute. So I think the officer can attest that we've tried to do everything as quick as possible to get everything obviously in this up to code. And
well, it sounds like you're moving in the right direction for sure. And it sounds like you were working closely with both code and planning to try to get this resolved. All right. Anything else, Mr. Avery?
Nothing for my part. Again, we just wanted 90 days to obviously complete the engineering and get it into compliance.
Understood. I appreciate it, sir.
Thank you, sir.
Officer Baza, what's the county requesting?
Bringing the property into compliance by Monday, September 14th, 2026.
September 14th?
September 14th.
So 30 days?
Approximately, I think, 33 days.
33 days? Do we think that they'd be done in 33 days or be able to get the...
I mean, we're not opposed to giving them an extra amount of time. I think we discussed it yesterday. If it's really up to how fast we can get the application in. I think planning is ready to try to get the application approved for them, depending on what they find. But
well, I guess I'm just saying I'm more inclined understanding how, some of these things take a little while.
Right.
And then even when you submit everything, you may get comments and then get kicked back and you have to resolve those issues. So, I mean, and there, some things are just out of the applicant's control, how quickly the county reviews things.
Yeah.
So I'd prefer not to set them up, to fail and then we have to have another hearing. And if we do, we do. I'm just saying, 33 days seems pretty short fuse to me personally, but, that's fine if that's what the county's asking for. What would be the requested fine?
if not brought into compliance, it would be $200 per day fine to accrue.
All right, and then admin fees, I have $122.
That's correct.
Anything else from the county?
No, sir.
All right, thank you, sir. Mr. Avery, I'll give you last word. You heard the county's asking for 33 days, $200 per day fine should it not be brought into compliance, and $122 administrative fee. I understand your request of 90 days. Is there anything else you want to comment on? All right, thank you, sir. All right, I'll close the evidence portion of this hearing. At this time, I'll make the following findings of fact and conclusions of law. I'll find that the property located at 159 Driftwood Road, Miramar Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence, I'll find that there is sufficient evidence to show that there is a violation at the property, specifically a violation of 1.13.00A, development approvals, and 1.13.09C, building permit requirements. Over the county's objection, I will provide that the property must be brought into compliance as Mr. Avery requested within 90 days. What's 90 days out? All right, so on or before November 10th. The property will need to be brought into compliance. Should the property not be brought into compliance on or before that date, a $200 per day fine will be imposed. In addition to the fine, there's a $122 administrative fee that will be need to be paid regardless of whether or not the property is brought into compliance. And I'll order that that administrative fee needs to be paid within 30 days. All right. I've signed the order. Did I miss anything from the county?
No, sir.
All right. Mr. Avery, you understand the order? All right. Best of luck to you, sir. All right. That concludes the case. Thank you guys for showing up. The next one we have is 250075. That case, we have the owner listed as the, looks like maybe the Patricia Piper's Revocable Trust. And the address is 218 Ash Street, that's ASH Street, Santa Rosa Beach, Florida. Is anybody here on behalf of the Patricia Piper Revocable Trust?
They won't be present. It's actually 26 also, 260005 or 75.
Yeah, 75, 260075.
May I approach to present my packet to you, sir?
Sure. Thank you. All right. Is the county ready to proceed?
Yes, sir.
All right, whenever you're ready.
I'm Code Compliance Officer Greg Forehand. For the record, I'm submitting my final summary report, presentation, and testimony in reference to case number 2600075. The property is in the unincorporated area of Walton County and subject to Chapter 7 Land Development Code, located at 218 Ash Street, Santa Rosa Beach, Florida, belonging to the Patricia J. Piper Revocable Trust, overseen by Cole Piper, her son. Violations listed are 1.1306 post-permit changes and 1.1309 C. Charlie building permit. Complaint was received on 2/6 of 2026 in reference to a potentially unpermitted structure encroaching on the right-of-way easement. On 2/10 of 2026, I initiated research of the property, along with communicating with Mr. Jim Harmon with Public Works per the complainant's request. For his determination, after them surveying the area of the right-of-way easement, and being advised by Mr. Harmon that the structure is 2 feet inside the easement, but not affecting or the area in a negative impact due to the location of the parcel. I then responded to the site, conducted an initial inspection, observing the structure and county survey markers, along with contacting the residents, which are renters there at the property. On 2/17 of 2026, I had phone contact with the owner, Mr. Cole Piper, with him confirming that his father had started the building around or before 2019, and he assumed it would be okay to complete it after his father had passed, not being aware of any other requirements at that time. I advised that the changes do require violations to be issued, and then explained the due process to potentially obtain approvals after the fact of the building being completed. On 2/25 of 2026, the notice violation was placed in certified mail and posted to the property on 3/3 of 2025. On 3/24 of 2026, the information regarding the accessory structure was submitted to the planning department, obtaining a BPR and beginning the review process. And then process was in continuance on 6/11 of 2026. I received information from the owner that he was awaiting the completion of a wetland delineation survey required by planning, and that delineation survey would make the determination if the structure would have to be removed or if he could move forward with any further of the considerations and the allowances. And on the 24th of June, he did get the returned outcome and passing all the approvals with the setbacks of the wetlands and percentages of to move forward with the next phase of approvals. On 6/29, though, I did advise that given the time that it passed, I would have to move forward with a hearing for this date on 8/12 of 2026. And due to it not yet reaching the point of approvals or permitting, on 7/8 of 2026, notice the hearing was placed in certified mail on the property and posted to the courthouse on 7/22. And we did have discussion yesterday with him advising of getting more updates. And he did send an email, which is in my packet as Exhibit 6 of a statement of absence of today because he does live in Tennessee and has work and family situation going on today. But my pre-hearing inspection yesterday did show the updated survey markers, and but the building is still currently there and the violation existing for him to continue with planning to work through. Email does show a statement that he is planning on working, continuing with them for the approvals and potential, I think I have to look at it. In the if a variance may be required due to the bid, I believe the bid of the drive-on portion going into the garage area may require a variance, and he says he's prepared to take that step once if the building is approved for everything else to be there.
So the issue is there's a county easement that affects part of the property, and then
Yeah.
that green shed is partially in that easement?
Yeah.
Okay.
Yeah, the far eastern corner there's a portion of it, it's actually not in it, but it's in the actual easement setback per se, yeah.
So you have a setback from the easement, would that be like a side yard setback?
Yeah,
on that
yeah,
side?
pretty
Okay.
much.
So 7.5 foot side setback from the edge of the easement would be imposed, and that sheds in that
Well,
setback?
yeah, usually it's like 20, I think the upright structure port, usually like 20 foot, because
Oh,
the pavement actually ends and their driveway is actually self-maintained and everything that goes down in that bottom. And that's why Jim Harmon said that they didn't see anything that where it would affect anything that Public Works would do any further development down there, because it is pretty much wetland where that property ends. The concern is if the property to the north side of there ever happens to develop.
Understood. What, is that like a platted easement, or is that like a separate written easement, or what kind of, I mean, how would somebody know that there was an easement?
It's actually on the county map as an easement to that, down to that point.
Okay.
It just, the pavement ends there, that hill down to there.
All right, and I do see the email that you referenced from Mr. Harmon.
Yes, sir.
About maybe missing today's hearing, but maybe seeking a variance or some other type of relief that was sent on, looks like this morning. Is that right?
Yeah, we discussed it yesterday, and he sent one, and it had a little bit too much in it, and I told him he might want to cut it down a bit, and he resent it this morning. He wasn't quite sure. He acquired the land through the passing of his parents, and he at a young age, and he took on a lot with it.
Now this email is from
Mr. Piper is the one that actually
Piper?
owns the property, yeah.
Okay.
Is overseer of the estate, rather.
All right. What's the county requesting as far as?
Due to his vigilance and trying to get everything, I told him I would request, the 90 days in his behalf, which will be November 10th, and with a $150 day, if not brought into compliance, and we do have a $122 administrative fee.
All right, thank you, sir. I'll accept into evidence the packet provided by the county. I'll go ahead and close the evidence portion of this hearing, make the following findings of fact and conclusions of law. I'll find that the property located at 218 Ash Street, Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find sufficient evidence to show that a violation has occurred at the property, specifically a violation of Walton County Land Development Code 1.13.06, post-permit changes, and 1.13.09C, building permit requirements. Based on that, I'll order that the property must be brought into compliance within 90 days, November 10th. So on or before November 10th. Should the property not be brought in compliance on or before November 10th, a $150 per day fine will be imposed. In addition to the fine, there's a $122 administrative fee that will be paid regardless of whether the property is brought into compliance, and I'll order that that administrative fee will need to be paid within 30 days. All right, Officer Forehand, does that miss anything?
Sounds good to me.
All right, thank you, sir.
Am I on the presentation? Am I clear to go?
Yes, sir, you're free to
Thank
leave. Thank you. Our next case is 260293. Property owner is listed as Larry and Robin Cheatham. Address is 57 Cypress Street in Freeport, Florida. Is Mr. Cheatham here? Or maybe Miss Cheatham? I don't see anybody. Okay. Is the county ready to proceed?
We are. May I approach?
Yes, sir. Thank you. Let me just look.
Good morning, Officer Harold Serrano, Walton County Code Compliance. For the record, I'm submitting my final case summary report and testimony for case number 2600293, location at 57 Cypress Street, Freeport, Florida, 32493. Property owners Larry and Robin Cheatham. Property is in the unincorporated area of Walton County and is subject to Land Development Code, Chapter 6, and the county ordinance. Violations cited: 1.13.09C, building permit; 1.13.00A, development approvals; 7.02.02 for overgrowth; 7.02.01A, junk and litter. Complaint was received on May 4th, 2026 for originally junk and litter. On May 5th, 2026, I conducted an initial inspection of the property, observed multiple vehicles on site that appeared to be inoperable. I also observed significant overgrowth as well as a boat absorbed in the overgrowth. Additionally, there were 3 structures on the property. 2 appeared to be mobile homes, and 1 appeared to be a shop that may have been converted into a main dwelling. I also observed an abandoned and inoperable RV. All 3 structures appear to be actively occupied and lived in. I attempted to contact the property owner by phone, but no response was received. Voicemail was left to request a return call to discuss the conditions of the property. On May 8th, a notice of violation was certified mailed to the property owner. On May 12th, the notice of violation was posted to the property. Still no reach out to the property owner at that time. On May 28th, I conducted a follow-up inspection of the property. I observed that there were no changes regarding the observed violations during the initial inspection. The NOV that was posted on May 12th had been removed. On July 8th, 2026, Notice of hearing was certified mailed to the property owner and received on July 14th, 2026. On August 11th, I conducted a pre-hearing inspection of the property and observed no changes or improvements since the previous inspections. All previous documentation violations remain uncorrected. I'd like to submit my packet and evidence at this time.
That'll be accepted into evidence. Have you had any contact with the Cheathams?
No, sir.
And do we know whether or not anybody's living in the main structure or in the home?
There's been no contact on it, so I'm not be able to get any answers from them. And so as far as I can see out, it was a shop at one point, but with the siding being erected up onto the side of the buildings and it looked like it was being used as a home. Also, the indication of the notice of violation, or I'm sorry, the notice of hearing was picked up by USPS. So somebody was aware of what was going on.
I did see that. And that's why I'd asked if maybe you had had contact, because it does appear that it was delivered.
No, sir. Nobody's reached out as well.
All right. What's the county requesting in this case?
Requesting 30 days to achieve compliance, $250 per day fine to accrue with an additional $120 administrative fee.
All right. Thank you, sir.
Thank you.
All right. At this time, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 57 Cypress Street in Freeport, Florida, is in the unincorporated area of Walton County, Florida, is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I'll find that there is sufficient evidence to show that a violation of Walton County Land Development Code exists at the property, specifically a violation of 1.1300A, development approval requirements, 1.13.09C, building permit requirement, and 7.02.01A, junk and litter. And there's one other, 7.02.02, overgrowth. Based on the county's request, I'll order that the property must be brought into compliance within 30 days. What date is that? All right, on or before September 11th. If the property is not brought into compliance on or before September 11th, a $250 per day fine will be imposed. In addition to the fine, there's a $122 administrative fee. I'll order that administrative fee must also be paid within 30 days, regardless of whether or not the property is brought into compliance. All right, that concludes that case. Thank you. Our next case is 260299, Stephen H. and Navarro Catherine Weiss. The address is 79 Bayshore Drive in Freeport, Florida. Are you Mr. You're Mr. Weiss? Okay, so it's Stephen Weiss and Catherine Weiss? Okay, great. Mr. Weiss, you've had the luxury of having to sit here a longer time than most, so you see how we're going to do it. So I'm going to let the county present, and then I'll give you the opportunity to present next. All right? Yes, sir. Is the county ready to proceed?
Yes, Your Honor.
Okay,
May I
hold on.
approach?
Yeah, hold on one second. Mr. Weiss, you're ready to proceed, correct? Okay, great. Thank you. Yeah, you may approach. All right. And Mr. Weiss, did you get a copy of the packet? Okay, great. All right, whenever you're ready.
My name is Officer Sarah Matrano with Walton County Code Compliance. I am presenting the case for the property located at 79 Bayshore Drive in Freeport, Florida. The violations cited are 1.13.00 developmental approvals, 1.13.09C building permits, and 2.02 1.00C RV living. On May 6, 2026, I conducted an initial inspection on the property. During the inspection, I observed 2 RVs with full utility hookups that appeared to be occupied, several storage buildings, and multiple utility trailers located on the site. A review of county records showed that a building permit was issued December 1st, 2021, and had expired, and there is no permitted primary structure on the property. A notice of violation was hand-delivered to the property owner, Mr. Wise, on May 13th, 2026. I explained the violations and the compliance deadline. Mr. Wise stated that he was working with a contractor and finalized documents in order to submit a building permit to the county, and that he applied for a BPR the day prior. A notice of violation extension was granted on June 17th, 2026, establishing a new compliance deadline of July 15th. A notice of hearing was mailed via certified mail, posted at the courthouse, and posted on the property July 10th, 2026. The property owner obtained a planning approval for the BPR on August 5th, 2026, which allows for temporary living of 1 RV. This approval was granted after the compliance deadline. As of today, violations remain for the RV living due to both RVs still being occupied and for the building permits, which has not yet been obtained. At this time, I would like to submit my packet into evidence.
All right, that'll be accepted into evidence.
We recommend the property owner to be given 60 days to obtain compliance or pay $150 per day until compliance is achieved. We also request the admin fee of $122 to be imposed.
All right, so just so I'm clear, what we currently have is failure to obtain a building permit or renew the building permit that has expired, the development approval requirements, and then violation of the living in RV and campers, correct?
That's correct.
And then you testified, and it looks like in your report, Mr. Weiss has submitted an application for a new building permit, but that has not been processed.
That's correct, sir.
And this began in May of this year. All right. Anything else from the county?
No, sir.
Okay. Mr. Weiss, do you have any questions for the officer at this time? Okay. All right. If you want to grab a seat, and then Mr. Weiss, I'll be glad to hear any testimony or receive any evidence you want to present. And if you want to come on up to the podium.
We have applied for the permit, and it's in the process of being looked at and approved hopefully soon. I'm pretty confident that 60 days is enough, but since it's not in my control, I'm asking for the maximum of 90 days to get compliance.
Okay. And is the plan still to build, or is the plan to just bring in a maybe modular home or something like that?
It's going to be a modular home that's getting put on pilings.
Okay.
So the home's actually already completed and been delivered to the contractor's lot. They're just waiting for the pilings for the permit to come out so they can install the pilings and then come and set the house. So
all right,
it's for sure thing.
Yeah, and you know, this has, I guess, been going on since May. You know, when we're in August. I'm almost inclined to kind of maybe split the baby. The county's asking for 60, you're asking for 90. Maybe put it. Do you think you would have it maybe done in 75 days?
Up to how quick it goes through the county's process and the
Yeah, I
building
know.
department. I mean,
And
as far
sometimes
as the
that's a
contractor
crapshoot.
goes,
I get.
they can drive the pilings in one day and
Right.
probably set it within 3.
Yeah,
But,
and that's
you know,
why that's what I'm getting at. It
That's-
seems like your case is a little more unique in that sounds like
The house
the
is
home
already
is
built.
already, is just waiting for the foundation, the pilings to be placed. Can't do that till you get the BP, building permit or development order. And, once you do that, then I think that resolves our RV and camper living, right?
Absolutely.
So, and it seems like you've already got utilities on site, so that, it's not like you're gonna be waiting a lot of time for that. All right. No, so I appreciate you being candid and,
If you don't mind, I also think, they can't get the CO until the septic goes in as well. So that's all been applied for, but that's through the state. I think they already have the permissions or permits they need for that.
Oh, so you don't
but that's
have-
another thing that's out of my control.
understood. So you don't have
so-
septic at this point?
No, there's no septic there on the property.
All right. Well, and as I said, I mean, I know the county wants to bring it to a conclusion. You do as well. I mean,
75 days should.
yeah. And like I said, if this was, you had a permit and it expired 2 months ago and things were running slow, I get that. Part of my, heartburn or concern is, the building permit was issued, over 5 years ago, and it doesn't seem like there was a whole lot moving. So, sounds like you are. I'm not gonna I'm not over here to beat you over the head about that type of stuff. I'm glad that it's moving in the direction it needs to move in. We just want to kind of keep that momentum going. So, I've got your request for 90. I understand the county's asking for 60. And it seems like it's just, only a matter of time before this is resolved. So that's always good to hear. Anything else, Mr. Weiss?
That's it.
Okay. Are there any questions of Mr. Weiss from the county? Okay. You heard, I'll ask the county, you heard Mr. Weiss, his request was for 90 days. What's the county's position on that? I know the county had requested 60. Are you still at 60 at your request, or?
Completely up to you, your magistrate. I'm not opposed to the 90 days.
Okay. All right. I appreciate that. Thank you both. At this time, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 79 Bayshore Drive, Freeport, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I will find that there is sufficient evidence to show that a violation has occurred at the property, specifically a violation of 1.13.00A, development approval, 1.13.09C, building permit requirements, and 2.0200C, RV living. Based on the request of the county and the request of Mr. Weiss, I will provide that the property will need to be brought in compliance within 90 days instead of the original 60 requested by the county. That's going to put us at November 10th. Okay, so on or before November 10th, the property will need to be brought into compliance. Should the property not be brought into compliance on or before that date, a $150 per day fine will be imposed. In addition to the fine, there is a $122 administrative fee. Mr. Weiss, that'll need to be paid regardless of whether you bring the property into compliance. Can you make that payment within 30 days? Okay, so I'm going to order that $122 admin fee. That'll need to be paid within 30 days. I'm signing that order, and best of luck to you, Mr. Weiss. Sounds like you're just need that extra time to get this brought across the finish line. So best of luck to you, sir, and appreciate you spending the day with us. Have a good day. You're dismissed. Our next case, and it looks like maybe our last case, is going to be 260235. Owners listed as Susan Hardy and Daniel Lickers. The address is 28 Quiet Water Trail in Santa Rosa Beach, Florida. Is anybody here on behalf of the property owners? All right, I don't see anybody. Is county ready to proceed?
Yes, sir.
Okay.
May I approach?
Yes, ma'am.
I am Officer Sarah Madrano presenting the case for property that is located at 28 Quiet Water Trail in Santa Rosa Beach, Florida. This property is in an unincorporated area of Walton County and subject to the Land Development Code, Chapter 7. The violations cited are 1.13.06 post-permit changes, 1.13.09 building permits, and 5.04.04B driveway approvals. On April 8th, 2026, I conducted an initial inspection and observed an accessory structure that was later determined to have been constructed without permits. I also observed a second driveway with additions made to the original planned driveway. A notice of violation was posted on the property as well as mailed April 10th, 2026. A notice of violation extension was granted and posted on the property May 15th. After the property owner applied for the BPR with the planning department. A pre-application meeting for the driveway variance was held on June 24th. No further action has been taken at this time. A notice of hearing was certified mailed, posted at the courthouse, and posted on the property July 10th. As of today, the property remains in non-compliance. I'd like to submit my packet into evidence.
Okay, that'll be accepted. What's the county requesting or recommendation on this?
We recommend the property would be given 30 days to obtain compliance or $150 per day until compliance is achieved. There's also an administration fee of $131.
You might have said this. Have you had any contact with the property owner?
Yes, Your Honor. I'm actually surprised they're not here. I've had great communication with them as they've been up to the planning department a couple of times. So I'm not sure if he is out, with work or, but they have not communicated with me today about not being able to attend.
Okay. All right. Thank you, ma'am. I'll go ahead and close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 28 Quiet Water, Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I'll find that there is sufficient evidence to show a violation has occurred at the property, specifically a violation of 1.13.06 post-permit changes, 1.13.09C building permit requirements, and 5.04B sub 5 driveway permit requirement. Based on those findings, I'll order that the property must be brought into compliance within 30 days, so on or before September 11th. In the event the property is not brought into compliance on or before that date, a $150 per day fine will be imposed. In addition to the fine, there's 131? Is that right? Okay, $131 administrative fee. That fee will need to be paid within 30 days as well, regardless of whether the property is brought into compliance. And I've signed that order. All right. And that looks like all of the active cases that we have. I have some orders that need to be signed. I can do that offline. And I'll go ahead and we are adjourned.